the judgment regarding that. In the context of insolvency, the roots of the bankruptcy law are to be found in the following procedures of the Roman law. This you will find quite interesting, a little bit background on the history part. Probably you wouldn't have known about how it all started. I'm not talking about the cross-border insolvency, but effectively the insolvency part, how it started in the world. The three procedures were the cessio bonorum, the assignment of the property, distractio bonorum, forced liquidation of assets, and remission and dilation, that is compositions with creditors. These procedures developed from individual debt collection procedures, which in turn gave rise to collective debt procedures, which we now see in the most insolvency regime, that we have a collective debt procedures. Individual creditors do not have the right to initiate any sort of litigation. It has to be done collectively. Insolvency law in Europe developed as a result of lex mercatoria. Lex mercatoria. It was the custom and usage that developed between merchants on the continent, the European continent, and thus influenced the laws of the country that had a more German or a Roman character. So there were some jurisdictions in which Romans had their own kingdom. So it was affecting most of those part of Europe in which Rome was the crusader there. Many European countries introduced some sort of bankruptcy legislation between the 13th and the 17th century. So the bankruptcy legislation goes back very, very long. So what they had was that in European markets, they used to put up benches in the markets, and they used to sell their wares in the markets. So whenever a trader used to get bankrupt, he couldn't pay his debts properly, then they used to break his bench. And that word was called bancarota, breaking the bench. And probably this bankruptcy words originated from that specific terminology of breaking the bench. So whenever the bench was broken, that meant that that merchant was no longer eligible or ready to pay its debt, and he was thrown out of the market. The central theme of the debt collection at that point in time was the gradual move from the execution against the person to a dispensation of execution against the assets of the debtor. You would be surprised that there were, till recently, 100 years back, there were special prisons for people who didn't pay their debts in England, in other parts of Europe. So the individual people, the person who was not able to pay his debt was thrown in the prison and was treated very badly. But after the coming of the corporate system of collective debt collection, this stopped. And I was talking to one of my British counterparts, and he was very vocal on about all these things, that the individual debtors were treated very badly who had failed to pay their debts. The first documented cross-border case was probably a case called Amanti Affair in 1302. It was the first cross-border insolvency case. It was situated in a place called Pistoia, which is now in Italy. It was a bank which went bank and was a risk that the assets would go away. There was also a race against creditors for the assets. Obviously, when someone goes bankrupt, the creditors want. Same thing is happening in the FTX case.
Sir, the audio is not coming properly, sir.
Okay, just a moment. Is it okay now?
Yes, sir.
It is okay, sir.
Okay. So in this specific case of Amanti, the Holy See, the Pope, was connected, and being a major creditor, with much to lose, he intervened. The Pope had huge amount of power that he could exercise within Europe, wherever the Roman Empire was there. So he intervened, and territory was not important semblance into that bankruptcy. Can you tell me which was the first Indian case of cross-border insolvency? Anyone can tell me? What comes to your mind when I say first Indian cross-border insolvency matter?
SR Steel? But no, sorry, wait.
You must be thinking about Jet Air.
No, sir. The famous construction company in.
There was two companies, that is Jet Airways and in which cross-border is.
So normally people would say Jet Airways. I would agree with that.
In the Videocon was, I believe that.
In the current scenario, it was the Jet Air case, but you would be, you would feel what I'm going to say now, that first Indian cross-border insolvency happened in 1908. That is almost 110 years prior to the Jet Air case, probably, right? And that was the case of McFadden and Company Limited. This person had two. He was trading. He had two companies, one in India and one in England, and the debtor had carried on business through these two companies. The English and Indian, the person died, and he went into insolvency. The English and the Indian insolvency representative negotiated a cross-border insolvency agreement that was done in Jet Air's case as well as a protocol. So it is not that we are very new to this. It is quite long way back that it happened, and both the courts coordinated properly to give a final effect to this sort of an insolvency of McFadden in 1908. The agreement that they entered into was subject to approval of the courts both in England and India. And somehow or the other, this thing, I do not have intricate details of this specific insolvency, but whatever we could find, I've just shared it with you. Now, just tell me one thing. What do you think about the cross-border insolvency? What does it entail? Can anybody tell me this?
Being conglomerate which are present in across the countries, and even let's take that, the banking and every operations has happened in different places, but we are looking at together solving the problem across countries.
Yes. So you're correct. You're 100% correct. The point here is that we as an Indian jurisdiction, we have not yet been open to much of cross-border cases, right? And cross-border cases are the most difficult to handle, because when you talk about cross-border, there are multiple jurisdictions we're talking about. There are various statutory obligations, the statutory acts that we need to take care of, and no country is going to give space to another country's statutory act, right? So this is important, that once we understand this, how it is to be done, how it is to be completed, how the procedures would go, that would make you understand what Part Z is. So I will not be focusing much on Part Z. I'll be focusing more on the model law on which Part Z has been based. There would be some provisions of model law which have been taken into our Part Z. There are some provisions of model law which have not been taken into Part Z. And we'll be discussing all those when we start discussing the model law. There are various points of view regarding the notion of international insolvency. And one thing just I would like to tell you is that during our discussions, just be very simple about not thinking about the IBC at all. Because once you start relating to the cross-border insolvency in terms of IBC, then you are biasing your opinions or your perceptions. So please don't do that. Just listen to what I'm saying and don't try to superimpose it on the IBC in any sort of a way. So there are various points of view of international insolvency. there's not a single set of insolvency rules that applies globally. Every case is different. In fact, all the states with developed legal systems who have developed bankruptcy and insolvency systems do not use one set of rules for all sort of insolvencies. It has to be completely different. In different situations, need different rules. So there are no single set of insolvency rules. It is important to have basic knowledge of the historical roots, essential characteristics of insolvency law. So basically, cross-border may occur for many different reasons. When we have an economic affairs with a foreign counterparty, I'm not feeling quite well, so sometimes I'll be coughing and taking some sort of a pill into my mouth. So please excuse me for that. So when we are dealing with some sort of a vendor who is outside the country or some sort of a customer who is outside the country, that may evolve into a cross-border insolvency scenario. If I have assets located in two different jurisdictions, I will be not saying country, I'll be saying jurisdictions. Please understand that. So when we are having assets located in two or more other jurisdictions, so when that company, which is say having an main office or main business in India, if it goes bankrupt, then the cross-border insolvency can occur if it has assets across different jurisdictions. But there are certain conditions applicable to it. We'll come to that later. If they are foreign creditors, that's simple. Contractual obligations that may fall under foreign jurisdictions and be governed by foreign law. Now, you must have read about certain agreements where if some party is taking something from you and you have entered into an agreement with them, they might be governed by English law, and the seat of the court could be London or Singapore. So those
mostly Geneva we have.
Pardon?
Mostly Geneva we have.
Yeah, Geneva or Singapore, or because see, Singapore and London, basically the arbitration and the mediations go there if it is an international agreement. They don't come to India. Probably they go to Geneva also. But I have mostly seen Singapore and London. Obligations that have been incurred outside the debtor's home country or are to be performed abroad. Some obligation, some sort of act needs to be performed abroad. So the rise of an obligation would be in its other jurisdiction, and that might also affect whenever the insolvency takes place, the cross-border issue can occur at that point in time. Now, there are different number of ways where we can classify legal systems, but there are two which are most common, which we have seen across the world: the common law and the civil law. Everybody understands about the common law and the civil law jurisdictions? I'll just explain it to you. The common law originated from England, the English crown, which used to issue written commands, normally what we call the writ jurisdiction. When justice needed to be done, was the basis of the common law. Since writs were not adequate to cover all situations, equity courts were eventually formed to hear complaints and develop suitable remedies based on equitable principles. And the basis of the sources of this authority came from the Roman law and the natural law. It became feasible for courts to seek up precedents and use them in current cases as a judgment, like we do in India. India is a common law jurisdiction. We use a lot of precedents of the Supreme Court or the High Courts of NCLAT to be used in different cases. So basically what common law jurisdictions countries are USA, UK, India, Canada, Australia. And what is well, before we go, how long is the Constitution of India? Can anybody tell me? There are 395 articles, 12 schedules, and 4 appendices. It covers a lot of ground. It covers a lot of ground. Now tell me, how long is the Constitution of USA? It's only 4 pages. 4 pages which describes national government consisting of legislative, executive, and judicial branch. It describes every one of them. It describes how the checks and balances are going to happen within these three branches. And it divides power between the government, the federal government, and the state. Only 4 pages does that. But it is said in US, it is not the parliament that makes laws. It is the lawyers who make laws. Because the precedents are being set up by the lawyers' discussion and their arguments. And that's why US, it is very important that you understand how the case law is going. It can change in a minute. If you have a case which is supporting you, a precedent which is supporting you, it could be reversed in a matter of couple of days. So it is very important that the use of courts precedents is very high in US. Most of the European countries use civil law because their system can be tracked back to the Roman Empire, and they were very strict. Effectively, civil law is one law where there are authoritative legal codes, and on the basis of these codes, you cannot go outside that code. You have to remain within that code. The basic concepts and norms of civil law are written in codes, specific codes and specific legislations. As these codes and legislation predominate, and the case law serves as a secondary source of law. It's not a primary source of law, the case laws or the precedents. And in the common law system, yes, precedents have a very important role to play. They're the primary source of law sometimes if the law is silent on something. So effectively, the countries which use the civil law system are China, France, and Germany. I'm telling you this because the difference between the common law and the civil law, because it has a huge amount of effect on cross-border insolvency. So how many of you have heard about the theories on cross-border, universalism, territorialism, and the modified universalism? Anyone? You must have heard of it in various talk shows, whenever there are some webinars, people talk about universalism, territorialism, and modified universalism. Anyone can tell me what they are?
Better you explain us, sir.
Okay, so let's start with the territorialism. It would be easy to understand. India is a country. Laws of India govern people within the jurisdiction of India. Nobody else can get into my territory. It is a state sovereignty which is the most important thing. Each country employs their own insolvency rules and regulations within their own jurisdictions. There is no recognition of foreign proceedings because it envisages that insolvency proceedings within a jurisdiction will have the effect only within that jurisdiction. No law is recognized which is outside that jurisdiction.
So just one understanding here. So
yes,
as we understand that most of our IBC or just for this purpose, I'll come to IBC, were framed based on UK system, right?
the basis of our law,
The way it was formed in UK.
Yeah. No, it is based upon a unilateral legislative guide, which gives you the options to any jurisdiction to frame laws as per its needs and requirements. And if you can go, if you go to the UNSTRAL website, you will find that legislative guide there. It is a very big document, almost 200, 300 pages. And if you can go through that, it will give you options within options. And it would be the countries or the jurisdiction which is going to legislate the law to keep some or leave some. It is exactly same what the model law says. Model law is not any statutory law or a procedural law. No, it is a law which, it is not even a law. It is a compendium of options given to different countries to take some and keep out. Like in a Lego board, you can take some blocks and put them here and then leave the rest of them out. So that I can explain it to you in a simpler way that way, right? So that is territorialism, where we do not accept any other law other than the laws of the jurisdiction, wherever you are situated. When we come to universalism, universalism is completely, I mean, if I can tell you this, the territorialism is that if a company has assets abroad, then they would and should be brought within the jurisdiction's powers, and then the whole process would run. Whereas universalism says that it focuses on the collective debt policy, where they would combine all the debts, right, from various jurisdictions, and try and do it from wherever the commis of the corporate debtor is, or the debtor, I would not say corporate debtor, but the debtor is there. It would be governed by the laws of the jurisdiction where the commis is, right? Commis is actually center of main interest. We'll be discussing in big detail about commis, all right? But that is also not possible. How can a country which is different from your country give you the right to put your statutory law and use them in your country or with their people? So these are the two theories which are on the different end of spectrums. So what happened was that lot of jurisdictions that relied on modified universalism, wherein they didn't take universalism as per se, and they didn't use the territorialism. They said that if a country has a debtor with a commis in, say, X country, or let's say for India, for that matter, India, however, India is not a signatory to the model law. So, and if someone has assets in Sri Lanka, for example, so both would be governed by their own legal systems as far as the bankruptcy or insolvency is concerned. But however, the procedural law would be somehow combined so that these two insolvencies can work hand in hand. The second option is that in the European Union, they have a special directive on insolvency, I think 848, which says that there could be a primary proceedings and a secondary proceedings. Primary proceedings can be initiated where the commis is located, and the other jurisdiction where there are assets or the other creditors or other issues are there, it can start as secondary proceedings. But secondary proceedings would be subject to the primary proceedings. Right. So we'll come to detail in that. So that is what modified universalism is. Let's get on to the next slide. Essentials of the framework of insolvency laws. Now, the essential of insolvency and bankruptcy law is effectively similar to what we have as per IBC. So I'll just take it one by one. There's some things which are different. The use of word insolvency and bankruptcy can be done on equivalent basis. We'll use them on equivalent basis as of now, because IBC uses bankruptcy more for the individual insolvency, but we'll use them simultaneously. Both of these words are actually having the same meaning in many different jurisdictions. And as you all know, that insolvency sometimes means the state of financial affairs of a debtor, whilst the bankruptcy refers to a formal state of being put into the formal bankruptcy, right? But we'll use them together. So essentials of the insolvency is that the framework is that the actions by individual creditors against the bankruptcy are frozen. In most of the jurisdictions where common law or the civil law, they are frozen, and the collective action is much more taken care of by using the collective powers of the claims that are filed, and individual action is not allowed. The assets are pulled into one common kitty, and once everything is taken care of, they are divided and given to the individual creditors as per the rule of the jurisdiction in which you are situated, or the law of the jurisdiction in which you are situated. For example, in Canada, the employees are only given an X amount, the maximum, say $1,500 or something for the employees. In India, we have that 12 months for the white collared and 24 months for the blue collared workers. So these sort of differentiations is there in most of the jurisdictions. Now the creditors are paid pari passu, that is pro rata out of the assets according to their claims. Now this is a very piece of ideology which is nowhere honored in India as well. Priority creditors and secured creditors are an exception to this rule, right? Like I said, we can have an argument on this, but a secured creditor, how can it be different from another creditor, right? In practical terms, few pro-rated unsecured creditors will rarely receive any sort of payment from the insolvent estate. Policy considerations. There are many policy considerations at play when analyzing or reforming a particular insolvency system. Now, what are the policy considerations? It could be pro-creditor or pro-debtor. India, we are using pro-creditor IBC system. However, pro-debtor a pre-pack. Whereas in US, we have a pro-debtor system where Chapter 11 takes care of the restructuring part and the rescue part. So where there is a pro-debtor, that is also fine. Where there is a pro-creditor regime, that is also fine. You have to go through the rules and regulations of each and every jurisdiction to understand how the cross-border would work. Now we come to the sources of legislation. I think it's getting boring, but we'll have to go through with it, right? Because we come to the exciting part a bit later.
Once in a while, you started off those controversies, no, sir. If you take a couple of minutes of detour, then we will be all right.
Okay. No, the point is that we are looking at it from a different perspective. We're not looking at it from an IBC's perspective, right?
Understood.
So we'll come to the interesting and the exciting part a bit later. Let's go through this theory,
Sure.
right? So the sources of legislation. When analyzing the insolvency law of a particular jurisdiction, it is extremely important to find the main sources of a particular system. Like I said, a civil jurisdiction or a civil law jurisdiction or a common law jurisdiction. In modern days, these sort of sources of legislation would be found in the codes, the acts which a jurisdiction might have. The US has Chapter 11. The bankruptcy code has many chapters. Chapter 15, Chapter 7, Chapter 11, which handles different sort of insolvencies for different sort of debtors. South Africa has multiple legislations which have to be combined to come to some sort of a bankruptcy regulation. And it is very interesting, the South African one. And the many legal principles also form part of general law. In some jurisdictions, you will find that there is no law at all, except that an administrator is there. And mostly in a civil law jurisdiction, the administrator is there. There is no insolvency professional or appointment holder. He takes care of all the insolvencies by appointing some person as per the rules and regulations. He becomes the insolvency professional. Then we come to the gateway and commencement. Now, what do you mean by gateway and commencement? How do you initiate the insolvencies? Every jurisdiction would have some sort of a gateway or the procedure whereby former insolvencies can be commenced. In India, we have a default, a debt and a default where we can initiate a insolvency under Section 7. Under Section 9, there should not be a pre-dispute situation. Otherwise, it can be started. So in different jurisdictions, you will find different sort of gateways. Now in certain jurisdictions, but I am very vocal about this, that we do not have much of this in India, is a director's liability for fraudulent or non-understanding of the trading when it has already got insolvent, because the first person who understand that they are getting into an insolvent situation is only the directors of the company. They are the first people to know that they are getting insolvent. In most of the jurisdictions, if directors know that they are in a situation where insolvency can occur, they can only trade or do business for maximum is 30 days. Beyond that, they would have to apply for the putting themselves into insolvency, and there are huge penal penalties also provided if they do not do that. Right. So these are some sort of gateways which would initiate an insolvency. I'm not talking about a cross-border insolvency, but I'm talking about a national insolvency, the jurisdictional insolvency. It is also important to determine the moment of commencement of the procedure for a number of reasons. The status of the creditors, secured or unsecured, will be determined with reference to their position at that point in time when the commencement procedure starts. In India, when we file and when it is admitted as an insolvency, there might be a huge amount of difference between these two dates. In some jurisdictions, it could be the filing date, which could be taken as the insolvency commencement date. It is different from different jurisdictions. So the effects of initiation, like we have in India, effects of initiation is an automatic stay, the moratorium that we talk about. Talking about the avoidable dispositions or the antecedent transactions that we call here in India as preferential, undervalued, fraudulent, and extortionate. A fraudulent conveyance entails the disposition of property by the insolvent, usually in form of donation or undervalued transaction, that therefore causes or increases the insolvency, while a preference is marked by the settlement of the pre-existing debt to a creditor or by affording such a creditor real security, thereby improving his position in insolvency. Then third, the effects of initiation is how the administration of the insolvency estate is going to happen. Many systems provide for a type of regulator or at least an official administrative office that has certain prescribed functions like supervision of the administration process of an insolvent estate, and sometimes extensive regulatory functions in relation to the appointment of insolvency practitioners. Supervision may therefore take place by way of some official body. The official body in India would be the IBBI and the IPAs. There's either some kind of regulator or in some system, it is the court itself which is regulating the IP. The majority of systems provide for office of an insolvent estate representative or an administrator, and they're termed differently depending upon the particular jurisdiction. The normal nomenclature differs from a liquidator, trustee, receiver, curator, or a syndic. Syndic is very French word, and it is usually in the French colonies or the French or in the jurisdiction of France it is used. The appointment procedures, prescribed qualifications, and regulation of estate administrators. By estate administrators, we include the IPs as well, differ significantly from system to system. Some systems prefer qualified accountants, some prefer attorneys, and some have no formal prescribed qualifications. Like we have in India, the IBBI actually tells that the basic criteria for becoming an IP. The fact of the bankruptcy must be advertised, like we have this, the third day publication made known to the creditor so that they know the status of the debtor. Provision will always be made for creditors meeting and filing of claims. So these are the common things that is there in each sort of a jurisdiction and the rules and regulations regarding the same. The estate administrator has to be appointed in accordance with the prescribed rules of the relevant jurisdiction, and provision must be made for the administration of such person, of such debtor, including the power to investigate, verify claims, realize assets, distributes the proceeds of the assets in accordance with the distribution prescribed rules, and an important task of the administrator is to trace assets. Now, in last, I think 6 months to one year, tracing of assets has become a very important part of the insolvency process. Earlier, as we were evolving, the assets were there in front of you and you could easily trace out the assets. But as and when we move into the insolvency, in the cross-border insolvency space, it would be difficult for people to identify the assets. So the tracking and tracing of those assets becomes very important, and it has become the same in India as well. There are a lot of webinars which are happening on tracking and tracing of assets. Probably one of the Insol conference which would be held in February would also be speaking about that. So, and the creditors would participate in the creditors meeting. Now, which creditors would form the committee of creditors is different from jurisdiction to jurisdiction. In India, we have the financial creditors who form the committee of creditors, whereas in US, it is the unsecured creditors which form the committee of creditors. So there are differences in the rules and regulation of how the committee of creditors is constituted. Now, regarding the distribution. The distribution rules or payments rules of creditors in insolvency will differ from system to system. But usually they draw a distinction between these creditors who rely on type of real security that is acknowledged by a particular system. The real security is different from when you have a real security, that means you are a secured creditor. So that is different from system to system. Creditors who have not established such a right of security at the time of commencement and who will thus in principle be treated as unsecured creditors. So at the time of commencement in some jurisdictions, you need to establish that you have a secured right to a property. Otherwise, you'll be treated as an unsecured creditor. Now tell me one thing. A very interesting question which has come up in last 1 month. A person who has a crypto asset, does he have a right on that or no? And that is where FTX, we will discuss about this. So who is going to be paid first? Who is going to be paid later? The waterfall arrangement. Every jurisdiction has a different waterfall arrangement. In our jurisdiction, in Indian jurisdiction, the operational creditor that the government goes down, way down. If we don't take into account the latest judgment, in some they are at the top. The government is at the top. Like I told you earlier, the employees in Canada are paid less at a X amount, which cannot exceed that X amount. India, we have 12 months and 24 months of payment made to them. So the priorities differ from jurisdiction to jurisdiction. Some jurisdictions have a priority rule. Very important, a priority rule, a super priority rule. In US, unless all the unsecured creditors are paid in full, you will not be able to pay the other creditor in certain circumstances. So these are the absolute priority rules which some jurisdictions have, which can have an effect on the distribution part. Now, very importantly, since all our IP is the cost of administration, that is what we get as our remuneration or the fees that we get from these sort of doing all these processes, running all these processes. The cost of administrating these sort of insolvency processes through an insolvency estate must be paid out by the proceeds of the assets that have been realized. Sometimes there would be a shortfall, and some system then oblige these creditors who have proven claims against the estate to pay the shortfall in accordance with their claims. If in certain jurisdictions, if the IP, the appointment holder, is not being paid because the asset of that debtor is very small, then it is sometimes the duty of the regulating authority or the government to pay them, so that these processes keep on working because without getting paid, nobody is going to work for the government or the regulator. So that takes care of our framework of insolvency part, and let's now get to the terminology part. Now, if Now, when we go through this terminology part, if you have any questions, keep asking them. Because when we go little later, then it would be difficult for me to come back here. Foreign proceedings. Now, these terminologies we are picking up from the model law. Foreign proceedings means a collective judicial or administrative proceedings of a foreign state, including an interim proceeding pursuant to a law relating to insolvency, in which proceedings the assets and affairs or debtors are subject to control or supervision by a foreign court for the purpose of reorganization or liquidation. If I start getting into the meaning of this in a detailed manner, it will take me at least 1 hour to detail only this thing. But effectively, in short, any proceedings which are related to an insolvency or bankruptcy of any debtor in a foreign jurisdiction would be called a foreign proceeding. Now, foreign proceedings can be of two types: foreign main proceedings and foreign non-main proceedings. Some European Union would call the foreign main proceedings as primary proceedings and the foreign non-main proceedings as the secondary proceedings. Things are the same, the terminology is a bit different. So, foreign main proceeding mean a foreign proceedings taking place in the state where the debtor has a center of main interest. I'll be explaining the center of main interest after a short while, but you understand what the center of the main interest is, that wherever the, in a nutshell, I'll tell you, where the registered office of a company is there, that could be, I'm saying could be, I'm not saying it should be, it could be that place where the company is registered, that could be the center of main interest of that company. But this presumption is rebuttable. It can also happen that company having its registered office in British Virgin Islands, and
can we say effective control exists where it is, like a corporate office in today parlance?
see, there is no one size that fits all, right? That's why I'm just trying to give you an example that if a company is registered in BVI, it may be possible that it might have its COMI in US, right? It might be possible that might have a COMI in UK, and there are cases where
Determined by the board of directors presence.
we'll come to that. Srinivasani will come to that.
Okay.
Come to that. That's why I didn't want to get deep into this at this point in time. Okay. So wherever, I would say, let's presume that wherever the registered office of company is there, we'll say the COMI is there, for just for the purpose of getting the foreign main proceedings and the COMI understood. Foreign non-main proceedings. So where the COMI is there, the foreign main proceedings would be recognized as such, and in all other jurisdictions, it would be foreign non-main proceedings. Right? Now, you cannot have two foreign main proceedings. But again, like I told you, cross-border insolvency is something where there are no set rules. You can even have two foreign main proceedings, but they would not be called as foreign main proceedings. They would be two concurrent proceedings running simultaneously in two different jurisdictions. Right? So this can also happen. So the foreign non-main proceedings are those proceedings in foreign courts which are not foreign main proceedings. Okay. Importantly, one thing is, read the second line: taking place in a state where the debtor has an establishment. Right. Now, how do you define an establishment? This is also very important. We'll come to it when we start describing the establishment, because establishment means where is there's economic non-tertiary activities taking place. Now, if you have one asset there, which building is there in a certain other country, and you want to open up foreign non-main proceedings there, probably you might not be able to do so, because the fact that the establishment is there has to be proven as per the definition of establishment. So we'll go ahead on this now. Foreign representative means a person or a body including the appointment holder on an interim basis, authorized in the foreign proceedings to administer the reorganization or the liquidation of debtors' asset or affairs, or to act as a representative of the foreign proceedings. In the Jeter case, Mulder was, I think R. Mulder was the person who was appointed by the Dutch court to act as a appointment holder in the Dutch proceedings. So when he came to India, he became a foreign representative because he has been appointed by a jurisdiction in that specific jurisdiction to follow the foreign main proceedings in India. So he becomes the foreign representative. Did you understand that? Any person coming into India as a IP appointment holder or an administrator of any sort of a proceedings which emanating out of other jurisdiction into India would be called a foreign representative. Any person IP in India going out to any other jurisdiction as a IP or an RP would become the foreign representative of that country or that jurisdiction. Foreign courts mean the judicial or any other authority competent to control or supervise the foreign proceedings in insolvency and bankruptcy. So there could be a court, there could be an administrative authority, which in some countries there are administrative authorities, not courts, which handle bankruptcy and insolvency cases. Establishments means any place of operations where the debtor carries out a non-transitory economic activity. Non-transitory, what does it mean? Permanent. With human means, goods or services. So having only assets in any jurisdiction without any economic activity would not entail that specific jurisdiction to include it as an establishment of that company. So foreign non-main proceedings cannot be started in those jurisdictions unless we can prove that establishment is there. These are the words on which most of the legal fraternity across the globe in insolvency and bankruptcy, they fight it out. Before we go on to the regionals, let me just tell you a little bit on the other terminologies. Something is called as burdensome assets, right? These are those assets. I'm just taking some terminologies from the legislative guide now. These assets have no value or are of insignificant value. They are called burdensome assets. So these are some terminologies which are different from ours. So we have done the establishment, insolvency representative. Then there is one Italian word, lex fori concursus. Lex fori concursus. It is the law of the state in which insolvency proceedings are commenced. Lex rei situs. That means the law of the state in which the asset is situated. So these are two normal Italian words. So what we call as restructuring plan is called a reorganization plan, and restructuring is sometimes referred to as reorganization. So they both can be used in different sense. So we now come to the regional initiatives. European Union regulations. These came into effect in the year 2000, and prior to this, 30 years prior to this, all the countries in Europe were discussing how to bring about such sort of regulations which can accommodate every country in Europe with a single law. On May 2000, 29th of May 2000, the EU regulation 1346/2000 on insolvency proceedings were adopted. They were recast as EIR, European Insolvency Regulation Recast. That was done in 2015. The number of that regulation was 848/2015, and it came into effect on 20th of May 2015. The insolvency regulation establishes a European framework for cross-border insolvency proceedings. The regulation applies whenever the debtor has assets or creditors in more than one member state, irrespective of whether he is a natural or a legal person. That means it is applicable for both individual and a corporate person. The regulation determines which court has jurisdiction for opening primary proceedings or the insolvency proceedings, the main proceedings. And the main proceedings have to be opened in a member state in which the COME is located. And the effects of this jurisdiction or the proceedings are recognized in the whole of European Union. Now, since we're talking about the European Union, we will be speaking in terms of primary proceedings and secondary proceedings. Primary being the foreign main proceeding and secondary being the foreign non-main proceedings. The secondary proceedings can be opened where the debtor has an establishment. The effects of these proceedings are limited to the assets located in that state. The regulation also contains a set of rules on applicable law and certain rules on coordination of main and secondary insolvency proceedings. When we talk about coordination and cooperation, it's a big topic which we will be discussing in the later part of this workshop. The insolvency regulation applies to all member states with the exception of Denmark, which does not participate in the judicial cooperation under the Treaty on the Functioning of the European Union. So Denmark is out. Britain is also out after Brexit, and lot of issues have come up in Britain after Brexit on their scheme of arrangements, their CVAs and all. So that is one thing that Britain has to live with.
Sir,
The
this
regulation-
one small doubt. This Britain or this Denmark, instead of European Union, we'll have to go by their own legislation, and we need to handle
Yes,
accordingly, right?
yeah. Exactly. The regulation provides for recognition and enforcement of judgments. Abhi kya hai? Let's take a scenario in an Indian legal system. You have won a case and a judgment has been passed for you, and you have that order in your hand, the judgment, which says that you can recover 5 lakh rupees from a person X. Now, what do you do with that judgment? How do you recover that money? You have to put in the execution proceedings in the court, and the court will appoint a bailiff or some person to help you recover that money through attachment proceedings or some proceedings or the other where they can recover that money. The point which comes out in the cross-border situation, in any sort of a scenario, whether it is insolvency or any other case, how do you, once a court in India gives some sort of a judgment, how do you execute the judgment in a foreign jurisdiction? That is a big issue. So for that, there are some principal documents which help on recognition and enforcement of judgments. So in EU, this regulation also provides for recognition and enforcement of judgments and decisions, allocation of jurisdictional competence, and harmonized choice of law rules. It is the most advanced effort so far to provide for cooperation and coordination in cross-border insolvency cases, but it is only applicable in the EU member states. There is another UNSTRAL model law on recognition on the of the foreign judgments, which is there. India is not a signatory to it as of now, but once you become a signatory to model law, you would also have to follow those if you become a signatory to that as well. Now, in different part of the world, we have another LOADA. Now, this is an insolvency harmonization legislation taking place in the context of Africa. This organization for harmonization of business law in Africa, with its French acronym LOADA, is part of a regional framework which constitutes almost 16 signatory states. 13 have ratified the treaty, and the treaty is open to adhesion by all member states of the Organization of African Unity. And it could even be ratified by and taken up as a model law by any other country in Africa. It should be seen as a part of regional economic policy and regional legal framework that would test the treaty and is mainly based on the French legal tradition, because most of the Africa was under French, was a French colony. So the French acronyms are used there. The French law is also used there. Like we are, like you said, Mr. Srinivasan said that we are basically following the English law. So the African countries are following the French basis of the French law, the civil law system. So the organization, which is relatively unknown, has established a number of institutions, including a common law court of justice and arbitration situated in Abidjan, Ivory Coast. The Montevideo Convention and the Bustamante Code. These are in Latin America in 1889 and 1940. The Montevideo Convention and the Bustamante Code were first found. These initiatives stemmed from multilateral conferences to address various issues in private international law, which included the insolvency law. But the insolvency law was only a part of it, a very small part of it. And the countries Argentina, Paraguay, and Uruguay are the three signatories to this. Then we come on to the Nordic Bankruptcy Convention. Nordic countries are Denmark, Finland, Iceland, Norway, and Sweden. So they have between themselves put up a Nordic Bankruptcy Convention in the 19th and 20th century, late 19th and the early 20th century. Many laws on central private law issues have essentially been the same in all the countries. This was not a result of formal harmonization, but rather a voluntary cooperation between all these countries. But now, some of them become a part of EU. So now this there is difficulty in terms of getting this Nordic Bankruptcy Convention in place. Treaties and other interstate agreements. Treaties and interstate agreements are traditional methods of coordination and cooperation between different jurisdictions. But due to the complexity and the sensitivity of the insolvency regimes, the treaties are difficult to negotiate and agree upon, because the recognition part becomes the major roadblock into getting these sort of agreements. So that takes care of our this. Now we come to the most important and exciting part that we are coming to. So many organizations like UNCITRAL, INSOL, International Bar Association, Committee J of the American Bankruptcy Institute, the International Insolvency Institute, the III, the American Bankruptcy Institute, the International Bar Association, Asian Development Bank, and the World Bank have all been working upon getting some sort of initiative on a law which could be applicable worldwide on a global scale, so that these differences in different statutory law and the procedural law can be minimized and the world can become one. One of the projects the IBA has been drafting of a Model International Insolvency Cooperation Act, that is MIICA, Model International Insolvency Cooperation Act. The Council of IBA adopted the Model Act in 1988. It is proposed for adoption by states with or without amendments. It is intended to further universality with the single administration of debtors' total estate, but not by means of recognition in foreign courts of one insolvency proceedings. While this act has served as food for thought, it has been recognized that the acceptance of the Model Act would depend upon ratification by a large number of countries across the world, and it has not happened as such. The latest initiative by IBA was the Cross-Border Insolvency Concordat, which was adopted by IBA in 1996. The approach is a little bit different than the earlier one. It is a set of principles which are intended to be presented to a judge in any cross-border insolvency case. If widely recognized by courts, these principles will provide some consistency. It has been, I mean, sorry, just a moment. It has been mainly utilized in the United States of America and has been referred to in some court decision, but again, this has not been widely used. The Unstral model law on recognition and enforcement of insolvency related judgment. Now, this is the main law which has already been signed by almost 50 countries, and it is widely in effect. The purpose of this law is the Unstral model law to create greater certainty in regard to rights and remedies of recognition and enforcement of insolvency related judgments, to avoid duplication of insolvency proceedings, to ensure timely and cost-effective recognition and enforcement of insolvency related judgments, to provide comity and cooperation between jurisdictions regarding the insolvency related judgments, to protect and maximize the value of insolvency estate. Where the legislation based on the Unstral model law on cross-border insolvency has been enacted to complement that legislation by the jurisdiction which is going to follow that. So it is going to be like in US, we have a chapter 11, which is basically there, section 7 to section 9. That's how I can put it, of restructuring. Then they have a chapter 15, which is a copy of the Unstral model law based upon their jurisdiction. So under chapter 15, they provide recognition of foreign proceedings. Now, I was supposed to give you more information on the Unstral model law, but I'll come to it later. First, we go on to the next slide, which is where we are going to start off with the COMI first, and then we'll come back to the Unstral model law. COMI, Center of Main Interest. This Unstral model on cross-border insolvency was built on the model of modified universalism. It was designed to ensure that a consistent approach to cross-border insolvencies, which would be coordinated via insolvency proceeding taking place where the debtor's COMI is located. However, the model law does not define a COMI. COMI is only defined by the legislative guide. So the main presumption as to the location of COMI is its registered office. But this is a rebuttable presumption. It can be rebutted that an ex-company, maybe it has a registered office in a jurisdiction that is not its COMI. The COMI is somewhere else other than that the jurisdiction where the registered office of the company is. The other factors relevant to determination of center of main interest as per the Unstral guide of to enactment is where the central administration of the debtor takes place. So if a company registered in BVI has its board of directors sitting in England or London, administering their business through a British subsidiary probably. So the central administration is taking place from London. So the UK becomes their COMI, not BVI, where the company is registered. The other option could be which is readily ascertainable by creditors. So if that company has an office in BVI and is being administered by people in London, but has creditors which gave the company their credit in US, perceiving that office in US to be their main office because the funds are flowing into that office and are being used by that office. That could also be the place where the COMI is located in US. Isn't it strange?
Sir?
Yes. Yes, Mr. Srinivasan.
No, we are able to hear you, sir.
Yeah, can you hear me?
Yeah, we are able to hear you.
Okay. So the COMI can now shift from BVI to London to US. Okay. This is how it happens. The COMI shifts. COMI can keep on shifting depending upon the perception, the facts, and the different legal mechanism in different jurisdiction, it can shift.
While
And
during the course of the proceedings, when we realized that, COMI is different from what was perceived at the beginning.
yes, so it can keep on shifting. All right. And I'll be explaining how it shifts, how when it will shift is very important. The timing of the COMI is very important in different jurisdictions. How it is different, we'll discuss that. So when these principal factors, these three factors, the registered office, the central administration of the debtor, where it takes place, and where it is readily ascertainable by creditors, these three factors do not yield an answer. Then the other, and all these parameters have come out from different case laws in different jurisdictions. So when these three factors do not yield an answer, a number of additional factors can be looked into, and these are, other than the location of debtors' headquarters, the location that a creditors can reasonably believe to be the place of business of the company, the location of those who actually manage the debtors, the location of debtors' primary assets, the location of the majority of debtors, creditors, or a majority of creditors who could be affected by the case, the jurisdiction whose law would apply to most disputes. This is very sorry. This is very important. So if a company has taken debt from creditors in US, so the US creditors would always say, okay, the law of US would apply, and the jurisdiction for any sort of a dispute would remain in the US. So that could also be a part where the COMI can shift to US. The place where the board of directors meets, place of residence of the directors or the managers, the place of main commercial transactions, the location of the bank accounts, the location of the employees and of human resources functions, the location of restructuring, negotiations with creditors, like I said, where the courts, which law would apply and which seat would be there, whether it is going to be the US courts, which would be deciding factor, or the UK courts or the BVI courts. So all these factors taken into account, the courts would then decide where the COMI is. If there is some sort of an issue regarding the COMI, the courts would then decide where the COMI is. Now again, an issue might crop up where the US court decides the COMI is in US and a BVI court decides the COMI is in BVI. Then what happens? FTX, that has happened, right? So we'll discuss it when we come to FTX, how what are going to be the calls that are going to be taken. So the first essential question that needs to be answered is, where is the COMI? Where is the COMI? So we have seen the various factors which would determine the COMI. And once that thing is determined, then the next point to be decided is when to determine COMI. The COMI is multifaceted analysis is there. It involves a consideration of variety of factors and circumstances. As a result, the point in time when the COMI is analyzed may determine the factors which are permitted to be considered. In a different jurisdiction, the timing of the COMI can be different. In EIR recast and chapter 15 concerning COMI, in the EI, the first one relates to the timing. That is the reference date at which COMI must be determined. Whether this should be the date when the insolvency proceeding is commenced or the date when the filing of the recognition of such proceeding in US is made. These two moments, like I said, filing of an insolvency proceeding in a jurisdiction and its replication for its recognition as a foreign non-member proceedings in a different jurisdiction. These two dates can be different in terms of the time between these two dates could be months and years, right? So for in the European context, when we're talking about, the COMI has to be determined when an insolvency application has been filed in the first instance. That is the primary filing. Whereas
Everywhere it will be the same, no, sir. COMI should be found at the initial itself, so that, like, unnecessarily wasting time
Okay.
on the wrong jurisdiction, we need to move the.
If in Europe it is found, if it is found that COMI at the time of filing, at the filing of the application is in Brussels, okay. In the meantime, the COMI shifts. Then what happens? The COMI shift takes place, and it has happened.
But at the inception, we need to have somewhere the base, and it can keep moving, no, sir.
No,
Should have
for example, it moves to a different jurisdiction, then it is governed by the different set of rules.
understood.
It cannot. It
But
cannot
we
be
have
governed
to
by-
have a primary COMI to be understood.
Yeah.
We initiate the proceedings, right? No?
Yes. In one of the matters that I recall, the COMI at the time of filing was in Europe, right? Then what they did was that they withdrew the filing. The filing was done by a holding company in Europe, in some country in Europe. I'm not remembering the name of that country. After withdrawing
The
it,
initiation by the company itself. You mean?
yeah, it is initiation by the company itself, but because of benefits attached to a US filing, the company made their holding company into a subsidiary of a US company and then filed Chapter 11 proceedings. Right. So company, the COMI can shift. We'll be talking about the shifting COMI by some case laws. So the determination of COMI in the first case law that we would talk about is, and by the way, when it comes to a US jurisdiction for, like I said, the primary proceedings at the time of filing, the COMI is important. When it comes to US for the purpose of recognition of foreign non-main proceedings, then the COMI at the time of filing that petition would be applicable at that point in time when the foreign non-main proceedings are filed, because if the COMI has shifted to US, Chapter 15 would go first. Then it has to be converted to a Chapter 11. Okay. So in the Eurofood case, it was, I'll just give you the brief facts of the case. A wholly owned subsidiary of Parmalat, this is a company, right, which was incorporated in Italy, it was incorporated in Italy. It operated through subsidiary companies in more than 30 countries. Eurofood was incorporated in Ireland. So the holding company is incorporated in Ireland and the subsidiary company is incorporated in Italy. In December 2003, certain insolvency proceedings were initiated with respect to the subsidiary, and the creditor applied to the Irish courts for the commencement of insolvency proceedings against Eurofood. Eurofood is the holding company. In February 2004, Italian court ruled that the insolvency proceeding should be commenced with respect to Eurofood in Italy as foreign main proceedings, declaring it to be insolvent and determining that the debtor's center of main interest was in Italy. Eurofood is registered in Ireland. Its subsidiary is registered in Italy, and Eurofood's insolvency has been started in Italy, taking its COMI to be in Italy because of that subsidiary. The Italian insolvency representative appealed the Irish decision. Now, the Ireland again said that the COMI of Eurofood was in Ireland, not in Italy. So the Irish, the Italian insolvency representative appealed the Irish decision. The Irish appeal court then referring certain question to the European Court of Justice for their preliminary ruling, because Italy and Ireland are both part of European Union. The question concerning the determination of COMI, the European Court of Justice ruled that if a debtor was a subsidiary company with its registered office, that of a parent and that of its parent company, two different European states, the presumption laid down in Article 3(1) of European Council Regulation number 1346/2000 on insolvency proceeding, which says that the center of main interest of that subsidiary was situated in the member state where its registered office was situated, could be rebutted only if the factors that were both objective and ascertainable by third parties indicated that the different situation existed. That territory of a member state in which its registered office was situated, by if a company carried on its business in the territory of the member state where it's a long thing, but then it said that Eurofood would remain in Ireland. The COMI would remain in Ireland because it would not be in Italy.
Thankfully, it was before Brexit.
Yeah, no, Brexit wouldn't have changed it because nothing has to do with England actually. In this case.
I said at least thankfully they were all together, so the decision would have been taken very fast.
Yeah. So, this thing. Just a moment. Before,
Sir, in this case, at least would you be able to tell us what made that decision? What helped them make that decision?
There would be, when the
This
decision comes,
Eurofood had a presence in different countries, and one of the subsidiary was in
Italy.
COMI was situated.
So the determining factors that we have discussed earlier, most of them would have been in favor of being Ireland declared as COMI.
The basic reason I'm asking, sir, Ireland would have been the base, which would have hosted several other countries also, including US or the Asian countries. There could have been some subsidiaries apart from.
Yeah. So
because the major the presence was also in US, no sir, for them.
Yeah, but Eurofood was now I do not have any. I have not read the judgment. These are some snapshots that we have in our books that we use. But the most determining factors of the COMI would have gone in favor of Ireland. Right, the management would be there, the bank accounts would be there, the creditors would be must have,
and the primary control might have been there only.
Yes. So that must be the reason that these things, the COMI would have been taken to be Ireland. And then the courts have flexibility in the application of these factors. So the courts are the determining agents for understanding the COMI. So their decision has to be followed. But in case there is two different orders of two different courts, then the issue becomes into a big problem. Then the Irish court says the Ireland is the COMI and the Italian court said Italy is the COMI, then it becomes difficult.
Particularly when the object has become more political rather than the facts.
Yeah. Subsidiaries COMI cannot be presumed to be of that parent company. It is because subsidiary would be an independent company by itself. Probably the holding might be different, right? The holding company might be having majority stake in that company, right? So but you cannot base the COMI of the subsidiary equivalent to a COMI of the parent company.
Would in this case, if the subsidiary alone has gone, the bankrupt in whatever the sense, whereas the holding company would have had the resources to pay the debts, being a conglomerate, would it be a different situation that it will be take different platforms, sir?
Srinivasanji, problem is this, that in a cross-border insolvency, nothing is fixed.
Okay.
Right. So if basically this is a strategy that has to be taken care of by the lawyers. If the Italian subsidiary has had cancer, so it is better to cut off that subsidiary, to put that only into liquidation. If the cancer has spread to many areas, right, then you can liquidate the whole company. Okay, so that is a matter of strategy, and strategy plays a very big role in cross-border insolvency.
But why do you say strategy, sir? Now, the country in which the subsidiaries, for example, will be benefited if you use the strength of the parent company. So then
There are a lot of
the jurisdiction should also help, but it's not just jurisdiction, but the prudence should be that you should make them responsible for even the subsidiary, no, sir.
Srinivasanji, the prudence only comes at the cost of losing money.
Okay.
Right. Now, if something goes bad, who's going to be the main person who's going to be affected? It would be the main mother company or the holding company. Right. The reputation risk would be huge in terms of future sales or future revenue earning. Right. So all these factors have to be taken into account when a strategy is prepared. For example, Eurofood has gone completely bankrupt, right? And now you have to take care of 30 jurisdictions. The cost of initiating a cross-border insolvency is in millions of dollars.
Understood.
Right. Now, if it's 90% of the assets are in 20 jurisdictions, right? So we can leave out those 10 jurisdictions. We can come back to them later. So those 20 jurisdictions would be where the strategy would say that, yes, these are the place where we can get the maximum benefit. The creators would only file there. They would not even look at those 10% in 10 jurisdictions where probably the cost of legal fees would be very huge. Probably more than the assets that can be realized.
And also that it would have been more sensible if because they rely more on the auditors and the public accountants or whatsoever. And obviously, if it all audited financial and there is no proof that there is any malified intention, obviously they can cut off the limbs this hand is this finger is broken or this.
So the point is that the goodwill, the brand gets sold also. So to sell that off faster, it would be beneficial to have some sort of strategy in terms of filings, in terms of negotiations with the creditors. All these things have to be
unless there is a lifting of corporate will. So
yes, corporate will
handled in respective
lifted only in case there is a fraudulent transaction.
That's what I'm saying.
Yeah.
Unless there is no lifting, that hiving of the or handling it in the subsidiary itself would be more beneficial.
Yeah, exactly.
Thank you, sir.
Now you very interestingly, India has some rules on the jurisdiction part. So if a company say it's registered in Mumbai ROC, so the NCLT Mumbai would have its jurisdiction, right? So if ROC Delhi has it, so Delhi NCLT would have their jurisdiction. No, the US is very peculiar, very interesting, right? Listen to me very carefully. There is a joke. there was one person who was coming from US. This is a joke. This is not something which is reality, but it is a normal joke in the insolvency circle in US and Europe. So he was supposed to file a insolvency against his company, for example. So then where is the jurisdiction? I mean, you are living in India, right? And you are saying that US would have jurisdiction to restructure or liquidate your company. How do you claim your jurisdiction? He said, sir, I was coming from the New York airport and I left my umbrella there. That is called the umbrella rule actually. So I left my umbrella there. And since the US laws say that if you have any property in US, you will have jurisdiction in US. So I have my umbrella in US, in your airport, in New York. That's why I have the jurisdiction to apply for my restructuring and liquidation in US. And that's
Sir, thankfully, you did not rake up the issues of state to state. We are in it.
I specifically did not rake up that issue because that would have been quite controversial, right? So in an actual case scenario, one company had given $1 million to their legal team in US, right? An advance payment for their legal issues. That company filed for Chapter 11 proceedings, and the question of jurisdiction arose and how that company, which is operating from a different country and have jurisdiction in US, the advance given to the US legal team became the property of that company in US and they had jurisdiction. Now, the question is, why would a country like US have these sort of rules? Why would an Indian company, if I am not mistaken, one of the ARCOM companies went to US for a restructuring under Chapter 11, right? So why would a company or a country have these sort of rules? Because why would Singapore have their own arbitration center running so many of arbitrations which does not have any jurisdictional issue with Singapore? It might be a country in Africa and a country in Asia having their arbitration in Singapore or London. The simple reason is that they have made their laws in such a way that jurisdiction wise, it doesn't matter to them where the business is coming from. If the business is coming, that's good enough. I don't care where it is coming from. Similarly, the US think tanks have thought that US being a very big country and having a lot of control over the world economy, everybody should come to them for their restructuring. And mind you, Chapter 11 is one of the best restructuring tool.
I can think of two things, sir. Singapore and US both. The transit economy is very large because of the trade finance. Then, like any other
Singapore is now becoming
more so
insolvency hub, right? Singapore is now, in the last 2 years, is becoming an insolvency hub. Otherwise, prior to that, it was nothing. They were not
because of the trade finance.
Yeah,
Because of the trade finance of billions
exactly
happens through Singapore, even not related to the neither the origination or ending is not in Singapore. That's the reason I would presume. And also that very interestingly, wherever the legal system is very good, they would welcome rather like, in their country, the legal system is being tried and people have got trust. US court or in Singapore particularly, the Singapore courts are more relied and the stringent system particularly that, the implementation of the law, wherever they exist in the world, they are able to bring them back into their country because of their cross transaction.
Now you are opening up a Pandora's box. Why didn't India become an arbitration hub or an insolvency hub Because the
You have just
timelines are not
included the chartered accountant, cost accountant, company secretaries along with the legal people in India now only, sir. Lighter
So,
wing. See,
the point is,
the finance people, we are thinking more about the finance, and we are going to augment the benefit for the advocate joining us.
so that is why India is not moving ahead in becoming an arbitration hub. The timelines are not sacrosanct here. If you go to Singapore, 5 o'clock means 5 o'clock. Any filing after 5.0, I mean, after 5 p.m.
But 5 p.m.
It could not,
talking,
could not
sir.
be done. It could be not
But the
done.
legal systems are so strong that, you know, NCLT should not have only one person, for instance, in Chennai, who will also partly sit in Delhi for half a day and come back to Chennai for the balance half of the day. And he will open up the cases, whereas in front of him, hundreds and thousands of cases have come in. He will handle only 10, 12 cases in a day.
Sir, I'm well aware of that.
This is
and
the manpower also.
Our thoughts have also been spoken about it in different forums as well. But
Tell
the
me,
point
sir,
is,
where is the dearth of professionals in India? And particularly now, you don't need the court also. You don't need a physical court. You can do the trials even on the web. Thankfully, the COVID has opened up the chapter. So why are
see, it is not the question of
Also.
the courts. It is the question of the mindset, right? If I tell you, have you done a pre-pack?
not yet, sir?
And have you seen any pre-pack being done?
Not really, sir, because we
How
are
much, okay, as per you, as per your professional perception, if a pre-pack is filed today, say on today, that is 9th of December, till which date that pre-pack would be completed?
even the court hearings in Chennai, if you ask me, it will take at least 1 year to come up to any logical, like, you know, decision from the court, sir.
Why? Because the
status,
mindset of all the stakeholders, I'm not talking only about judges.
No,
I'm
sir.
talking about
Forget
all the
about stakeholders, sir. Sir, now, seriously, we are landing up in situations whereas the case is discussed and finalized. The decisions are given
I'll tell you,
or
in
two
US,
even.
in US,
And you know, sir, what is the loss that those cases? 70, 80 crores of money being taken away, slashed away from the corporate debtor, and we are not able to do
compare it with US. The fastest pre-pack in US
Sir,
was
I was
completed
about to
in,
tell you all this cross-border when you mentioned about Chapter 11. I was thinking in India, we all wish that it is the finance creditor whom we represent, because the moment you step in, if you are not a finance creditor, even after finance creditor, you may be replaced. But if you are not from a finance creditor, 200% chances that even appointed by the NCLT, they are replacing it coolly with the decision of the COC, and they are replacing mercilessly, like, you know, the people.
so coming back to the US, the fastest pre-pack in US was completed in 19 hours, right? That is the mindset.
I'm hoping that next decade we can see this in India, sir.
No, and coming back to
Achieve
your,
earlier, it's really amazing then.
coming back to your earlier comments of financial creditor and the change of IP, we are the ICSI is conducting a webinar tomorrow morning, right? And I am the speaker there, and I'll be telling you about something else on business rescue and turnarounds, right? Where you operate outside the scope of IBC problem. So don't let the companies get into IBC anytime.
Truly, sir. That's what I'm telling the bankers, that, you know, give us the cases when they are not gone into that, and we will try to do the structuring for them. And bankers are also
coming
believing
back to the
that IBC and CBI, they don't want to believe, sir. Some of the bankers openly, they tell us, personally, when they tell us, we don't believe in either IBC or CBI. Both of them, they are trading on the same platform. Earlier, CBI was only in that platform. Now IBC has also moved into the same platform, because no decisioning happens for
So this is an evolution of a code where it is not even an evolution of a code, is the evolution of the stakeholders as well. How the judges think, how the creditors think, how the debtors think. So all these matter. And once they come onto a platform where the thinking matures and the thinking evolves, things would start getting better into place.
We
Right.
wish, sir. We
Yeah.
are wishing, wishful
So-
thinking. We have come up to this stage. We are very happy for the IBC, but we need to go a long way. We need to all fight shoulder to shoulder successfully.
So coming back to the Comey shift. So US Chapter 11 filing jurisdiction, I've told you, may change registered office, laws and rules in home country. Because why does Comey shift is also a question that laws and rules in home jurisdiction are not conducive for insolvency. Why would an Indian company go to US for Chapter 11 proceedings? Because there the restructuring are much more faster, much more easier, and it is applicable all across the world. Then it can also happen because of the contractual governing laws. Like I told you, the governing law may be England, or maybe the courts of England have the jurisdiction to do that. So that can also be one of the reasons. So what we can do is that we can have a 10 minutes break.
True, sir.
Shala,
It
can
is
we
the
have-
right time. We can resume back at 3.
Yeah, we can resume back at 3. Shala, is it okay with you?
He's already taken the break.
Okay. Okay, let's get back at 3 o'clock and then we'll start the model law. And this is going to be exciting. Okay.
True, sir.
Right. Okay.
We also taking the how do we handle this cross-border cases? Looking forward some inputs from you. Do we
Yeah.
what kind of the panel that we need to build up?
Yeah. Definitely we'll talk about that.
Thank you.
Okay. Thank you.
जितने डुप्लीकेट है ना वो आ जाएंगे हमारे पास, उनके ही नाम चेंज करेंगे हम।
Can we start?
Sure, sir. Sure, sir.
Hello, Trishala?
Yes, sir, you can start.
Okay.
Okay, sir.
Well, we have been talking about Install model law. Now I'll be explaining you the details of whatever model law contains. So we had talked about that MIICA happened in 1997 and thereafter the Concordat happened. But the MIICA was not very successful. So in 1997, the INSOL and the IBA sat together, participated actively in the work of Install, and conducted within a very short span of time and drafted this model law. Now, model law is not an international convention. It need not be ratified by the states. It is not a convention, but a set of provisions on cross-border insolvency to be implemented with or without amendments. You can take some things from model law, keep them. You can throw something out, what you don't like. So you can use them in whatever way you feel like in your national legislations. It is not a legally binding instrument, the model law. Therefore, it was easy for the states, the various jurisdictions to negotiate on it, and it was not compulsorily thrown onto them. They had the option to choose, pick and choose whatever clauses they could choose from the model law. The model law on cross-border insolvency was adopted on 30th of May 1997. It was designed to assist states to equip their insolvency law with a modern, harmonized, and fair framework to address more effectively instances of cross-border proceeding concerning debtors experiencing severe financial crisis or distress in insolvency. These instances included cases where the debtor has assets in more than one state, or where some of the creditors of the debtor are not from the same jurisdiction, or the same insolvency proceedings jurisdiction. The proceeding pending in the debtor's COMI is expected to have principal responsibility for managing the insolvency of the debtor, regardless of the number of states in which the debtor has assets or creditors, subject to appropriate coordination procedures to accommodate local needs. So basically, it helps in coordination of the procedures rather than the substantive law. The idea of the Install model law that the states shall implement the model law into their existing laws, which may require adaptation to a greater or a smaller extent. However, the closer to the original model law that the states implement, the better it would be, since foreign practitioners could then easily understand and interpret the law because it would be almost the same in each and every jurisdiction. More importantly, this would create reciprocity. If it is same, then it is easier for one jurisdiction to reciprocate in the same way or the form which the other jurisdiction would reciprocate itself. Whereas not necessarily reciprocity is the basis of cooperation or coordination of proceedings in model law. It can be just understanding the whole scenario of the model law and cooperating on that basis. The lack of reciprocity doesn't mean that certain issues could not be included in the model law. For example, choice of law rules, which was not included in the model law, which makes it a little bit incomplete, but yes, for a better majority of the states taking and signing the internal model law, it would have been better, but it has been better than the earlier models that have been put into place where they have not been much of success. Model law has been signed by almost 50 countries now, and the number is growing, and India is expected to sign it in the near future. Model law consists of 32 articles in 5 chapters. Some provisions are intended as minimum rules, and in some cases, alternate provisions are also given. Over the past several decades, two legal developments have enabled cross-border restructuring that would have been impossible a generation ago. The first is the partial replacement of the territorial system that we discussed in the theories of insolvency, in which each country's insolvency law deals independently with the assets within its borders, with an approach called the modified universalism, and is reflected in, among others, the install model on cross-border insolvency. So basically, install model law is based upon the modified universalism theory. So the basic premise of a modified universalism is that if a debtor commences a restructuring proceeding in its home country, where it has its COMI, courts in other jurisdictions should defer to that proceedings and be ready to conduct ancillary proceedings to assist the main proceedings. The US had adopted chapter model, this install model law in its chapter 15 code. The second development works in the opposite direction. When the debtor determines that the restructuring laws of its home country are suboptimal for its restructuring processes, then it can export to another jurisdiction to use that jurisdiction's laws for its own benefits. This has been happening where a company registered in BVI having its establishment in UK and in its people in, say, in Cayman Islands and doing business in US, major chunk of business in US, gets its restructuring done in US. That is possible as per the different laws of different countries. So when we talk about the install model law, there are 2-3 things that are very important when we talk about the model law. I do not have a slide on that, but yes, I will be talking about that. Article 6 talks about public policy exemption. Sorry, public policy exception. Be it the arbitration law, the internationally, or the mediation law internationally, there is always one clause which tries to bypass the laws, which is the public policy exceptions. So what the Article 6 says is that the court of the enacting state shall have the power to refuse an action where it would be manifestly contrary to the public policy of such state. In simple words, if a debtor from or the appointment holder of the debtor in UAE approaches Indian courts for something which is manifestly contrary to the public policy of India, then the Indian courts can refuse recognition. So if something which is against the public policy in India of an act, which is being supported, acted, or asked for by the parties outside India coming to NCLT, they would refuse it. But the term public policy has not been defined in the model law. Because the notion of public policy derives its existence from the domestic laws. Because every country would have a different sort of the public policy on different topics. And it also has, the industrial model law has recommended that the interpretation of the notion of public policy must not be wide, and limits should be imposed upon the court's discretion to invoke its exception. This exclusion includes denial of recognition. The courts in UK and US, and UK are very developed, has very developed insolvency regimes and courts. US and UK in many cases have adjudged public policy exceptions in the insolvency and bankruptcy field. Have actually adjudged them in a very narrow manner. They have not made it very broad. They have adjudged it in a very narrow fashion and passed orders despite the action being against the public policy. And this has been done on the ground of comity. We help you, you help us. These jurisdictions have evolved because of the long jurisprudence in the cross-border cases.
Sir, your voice is breaking between.
So I think there is some issue with the. Is it okay now?
Yes, it's fine.
So the public policy exception has to be distinguished as between the notion of public policy as it applies to the domestic affairs and the notion of public policy as it applies to the international cooperation and coordination of the courts or the stakeholders between different jurisdictions. Now, the word that has been used in industrial model law is the manifestly contrary. Now, the model law being not a law, but a authority where people can pick up some things and leave some things. So some jurisdictions have removed the word manifestly from the provisions of model law. So they can become contrary to public policy. So these are things that various jurisdiction can do to take some things from model law and leave some things from model law. To give you a case example of a public policy exception is that one Canadian insolvency representative, this case is in FEDRA products liability litigation. The case law is this. The Canadian insolvency representative of a Canadian debtor applied to the US court for a multi-district product liability litigation, which was pending in Canada against the same debtor, for the recognition of Canadian insolvency proceeding as foreign main proceedings. Now, when these people, Canadian people, put up this application for recognition of foreign main proceedings, the normal procedure was like we have it in India, that the claims were to be adjudicated by the professional, the insolvency professional. But in US, this is the fundamental right of all citizens to have jury trial in case of these sort of product liability cases. So an objection was raised by some of the people in US that since they do not have access to any jury trial or a recourse for their claims, this would not be the foreign main proceedings of the Canadian jurisdiction should not be recognized by the US courts. Now, this is a very big public policy which is a fundamental right of every citizen in US to have a jury trial. Thereafter, the Canadian the resolution professional changed the process that they would be given an option to finalize or before the claim is accepted or rejected, they would be given a trial to given an option of being heard personally. So this was done by the Canadian RP. So on the basis of this process, the US court said that the fundamental right of a citizen to a trial by jury has been taken care of by giving them an option to be heard upon before finalizing their claims, and they narrowly used this word manifestly contrary to public policy, stating that it is taking care of the jury trial by giving an option of being heard upon to the US citizens who are having their claims with that Canadian company. And they said, yes, now we will grant recognition to the foreign main proceedings of the Canadian company. So effectively, what they did was that an action which was not supposed to be which was supposed to be very, very important to the US citizen of a fair trial under a jury, this was used not in a very narrow sense, not in a broad sense, and the recognition was given to the Canadian company. Wording has to be used very narrowly in terms of an international process.
So it is just
Then the
circumventing,
other
sir.
word that is, pardon?
It is just circumventing the provisions of US.
No, it is not, because in an international scenario, if something is manifestly contrary to the public policy, then it can stop that state from recognizing the other proceedings. In a similar case, in another case of Gold and Honey Limited, where the company started proceedings in Israel, and they were not in consonance with a normal common law traditions of setting up an administrator or a resolution professional. And when they went to US for asking for a recognition as foreign main proceedings, it was denied on the basis because it was not a collective uh, uh, bankruptcy proceedings, it was an individual bankruptcy proceedings. So it has to be seen on a case-to-case basis. And this is very important that India also has, in the part Z, it has used the word public policy, but since this has not been legislated, I would not comment on what is going to be legislated. I would rather comment on what is legislated, because
This
it can
is more
change.
to do with the public policy will have more to do with the personal insolvency, sir, not the
No. It
or even
can,
there.
so it can be, see, anything which has to do with the policy of a state would be included in this specific wording. And it can be different from a case to case. It cannot be either, it can be, yes, in an individual matter, it can be in a corporate matter as well. So because we are common law countries, so most of the things come out of the natural law as well. Right. But in the civil law countries, this becomes a little bit problematic. So the next thing is what we're going to talk about is the comity, international comity. Remember the jet air case, where the Dutch representative came to India, and when he came to India, he gave an application to NCLT for recognition of their proceedings as foreign non-main proceedings. NCLT refused and dismissed the application. This application is outside its scope, because there was no provision of recognition in Indian bankruptcy code. So when NCLT took it and adjudicated on that application in affirmative in favor of the Dutch representative, just give me a moment, please. So when they gave this decision in favor of the Dutch representative, It was done on the basis of comity. Now, what is comity? The recognition which one nation allows within its territory to the legislative, executive, or judicial acts of another nation, having due regard both to international duty and convenience and to the rights of its own citizens or of other persons who are under the protection of the laws. Basically, what it is, what this is what Justice Gray in England said about comity. Now, what basically it tells is that one legislature in a specific jurisdiction giving respect, regard to the orders and the jurisdiction of the other jurisdiction, right? So comity has to be taken care of if you need to execute some judgment in some other jurisdiction. So it can be done on the basis of reciprocity or in the basis of some sort of agreement entered into between two different countries, or if both the countries are, say, signatory to the model law. So we'll just, I wanted to tell you about the case law, but then we have very less time now. So I'll just skip to the next part of the Unistral model law.
Sir, would you have a list somewhere where we can access who are all territorial, who are all like, the modular, and who are all like, the...
No, there is nothing of this sort.
All
These
this
are
sort.
only the theories. Now, if a country or a jurisdiction say that, okay, we'll use the theory of territorialism, then all inbound cases would not be there, and they would not also go outside.
How do we know when we take up the case?
Sir, again, we cannot choose a case. The case chooses us, right? So when the case chooses us, you have to work within the framework of whatever is presented to you. For example, you're presented with roti and dal, right? And you are a rice eater. So if you are hungry, you'll eat roti and dal. If you're not hungry, you will not eat it, right? So whatever facts or the circumstances or the situations are presented before you, you have to bypass between those lines only and get out. Mr. Vinod Kothari on the first day of this ICSI program was talking about that. He actually sees it in terms of people eating food. If there is enough food, there is no insolvency. And if there is less food, how will the people eat? So I was just thinking it in the terms of cross-border, that if there are 5 people in India and 10 people in, say, Bangladesh, and there is a cross-border insolvency and there is less food to eat, and how it is going to happen there in different countries. Probably if we have meat here and there are no meat eaters. So in terms of that, it becomes a very difficult situation for everyone. And mostly when a person or a company is in an insolvency situation, either nationally or internationally, everybody can't eat. Only some people will eat. Those people might be the powerful, like the secured creditors, or they would be the workmen, or most probably IPs like us, who will get the first chance to the super priority rule.
We have a lot of questions to ask you on debate, but I think this is not the right time. We will ask CS Institute to once again call for exclusive time with you, sir.
Okay, anytime. So the next part is that what so Unistral model law provides the key provisions to start and finalize insolvency, cross-border insolvency. The key provisions are the access, recognition, relief, cooperation, and coordination. So when we talk about access, the provision on access addresses both inbound and outbound aspects of cross-border. So an Indian RP who is handling a situation where there are assets in Dubai, for that matter, so that he can access Dubai courts for putting those assets into a collective kitty. That is what access is all about. Like the Dutch representative in the Jet Air case came to India to get recognition on his foreign non-main proceedings. So that was an inbound, and the Indian RP going to another jurisdiction to get some sort of recognition is a place where we we understand is the access part, the key provision of the access part. So Article 9, we spoke about Article 6 for the public policy part. The Article 9 speaks of right of direct access. So the right of direct access, it is without doubt that any RP, any appointment holder, any administrator, any liquidator can access the other court. Now this access at what point in time is also depending upon jurisdiction to jurisdiction. Some have a right of direct access without any proceedings in place. Some have a right of access when certain proceedings have already been initiated. Like in Netherlands, when the Dutch, I'm using the Jet Airways case because all of you almost have read or heard about it. So when the Dutch insolvency court put Jet Air plane, which was standing at the Schiphol airport, they initiated the insolvency case and moratorium was declared. But since Jet Air had its COMI in India, the Jet Air RP in Dutch came down to India with an application to be recognized as non-main proceedings, foreign non-main proceedings. So the proceedings were actually initiated in Netherlands. Thereafter, while he was coming to India, proceedings were initiated by State Bank of India in India, which were then recognized as foreign main proceedings. So the right of access is there. Then Article 10 speaks about the limited jurisdiction. Now, what is this limited jurisdiction? The sole fact that an application pursuant to this law is made to a court in this state by a foreign representative does not subject
Sir, your voice is not audible again.
foreign jurisdiction. Anyway, is it okay now?
It's okay, sir. It was breaking, sir, like a network error only.
So that you can understand it perfectly. So the Jet Air
Sir, you are muted, sir. No. You have to remove the mute, sir.
I think I'll have to stop this PPT again and restart it. Just give me a minute. Am I audible now?
Yes, sir.
Okay.
Yes, sir.
So if the Dutch authorized representative or the insolvency representative comes to India and petitions the Indian court for recognition as a foreign non-main proceedings of the Dutch insolvency proceedings, he's only submitting the assets of the debtor to our courts. He's not submitting himself as it is not submitting himself to the Indian court. That Indian courts cannot force him to do anything. Only the Indian courts, what they can do is that they can force the assets of the other country in the other country to be adjudicated upon by the courts of that country through some means, but it cannot force itself on the representative itself. So that's the limited jurisdiction under access. Then we go to Article 11. Application by a foreign representative to commence a proceeding under the law to insolvency. This effectively is for commencement of the insolvency in a specific jurisdiction. Then the Article 12 is about the participation of foreign representative in a proceeding under laws of the enacting state relating to insolvency. So Article 11 is filing of the proceedings by the Dutch representative in India, and Article 12 is about his involvement in the Indian proceedings as the Dutch representative of the Dutch insolvency proceedings in India. When we talk about the jet air case, this would become very apparent. So the application needs to be filed for recognition of foreign proceedings under Article 11, and I'll just tell you in a very short way how the application is going to be filed. The application needs to be in a written form. The application needs a certified copy of the decision of the, if you're talking about a jet airways case, the Dutch court's order needs to be there. The certificate from the Dutch court needs to be there regarding the existence of the foreign proceedings, and some sort of details on whatever has been happened that should be attached with that application under section 11, the Article 11. So that is what section Article 15 says regarding the application. Article 16 is on the presumption concerning recognition. Now, whenever documents from one country goes to another country, they have to be apostilled, right? Like हम नोटरी करते हैं, अगर मैंने यहाँ से कोई डॉक्यूमेंट मुंबई भेजना है या चेन्नई भेजना है, so I would notarize it and then send it. That would actually show the authenticity of that document. But when we talk about international concept, then there is a Hague Convention, which actually was earlier there. Now it has been called the Apostille Convention, where the documents are apostilled by the country from which they are coming, and they need not be reconfirmed by the other country. So, but the presumption is always there for the courts where which the application under section 15 is filed, presuming that all these documents are in proper order, and only in case there is some sort of a doubt about the validity or the originality of the document, only then the courts can ask for further
Sir, basically MOCI of that respective country and the foreign ministry has to certify any document, no sir?
Yes, that's an apostle, which is in the Indian context. What you are saying is right. Right.
It is similar in all the countries almost.
Yeah, yeah. Maybe the authority which is confirming it might be different, right? But the process is the same, right? So, for decision to recognize a foreign proceeding, subject to the Article 6 of public policy recognition, a country can recognize the foreign main proceedings within the meaning of article, if it is in the meaning of subparagraph of Article 2, that basically says the application meets the requirement of Article 15. The application has been submitted to a court referred to in Article 4, and the foreign proceeding can also be recognized as a foreign proceeding if it is taking place. Like I told you, foreign main proceedings can be recognized, the COBIs in whichever state it is. Foreign non-main proceedings can be recognized where the foreign main proceedings are not there. So the decision to recognize would depend upon COMI and the how the application is filed with the concerned court. Then we come on to the relief part. Now, the relief part is divided into three articles. Now, all these articles could look like same to you, but they are completely different in terms of the reliefs. Article 19 is basically an interim relief. For example, if you see it in the Indian context, Section 7 application filed, admission would take place around after 9 months or 10 months. So interim between the filing of the date of filing of that application and the date of admission of that application. So what Article 19 says that at the time of filing the application and at the time of the recognition order that would be given, the interim, whatever interim relief is asked for, that could be given or should be given, and that could also include moratorium. Okay. And Article 20 speaks of the relief given after the recognition of foreign main proceedings. That means on the recognition of foreign main proceedings, the interim relief would be stopped and moratorium execution against debtor assets is stayed, right to transfer income or otherwise dispose of any asset debtor is suspended, and in whatever interim relief has been given, that may stop unless it is required or asked for or prayed for in the application. Then it would again start if it is ordered by the court. And in case whatever is not granted under Article 19 or Article 20, if extra relief is asked for, Article 21 can be used for that. Article 20 has been okayed by the Committee on Cross-Border Insolvency in India. However, any modification or termination of stay and suspension has not been taken into account by the in the Indian cross-border insolvency regime as per the bill of the Part Z. While relief under Section 19 and 21 are discretionary, but the relief out of Article 20 which flows automatically out of the recognition of foreign main proceedings, and Article 19 and 21, the reliefs can be stopped at any point in time. So these are the difference between 19 and 20 being the discretionary relief, and Article 20 it flows out of the foreign main proceedings, the recognition part. The reliefs which are given in the model law and adopted would flow from effect of Article 20. Now you have seen the access, recognition, and the relief. All these three things are useless unless there is a cooperation, coordination, and communication between various stakeholders, between the courts, between the IPs, and between the creditors. Section 25 talks about cooperation and direct communication between a court of this state and the foreign courts or foreign representatives. By foreign representatives, we mean the IPs appointed by the foreign court or the Indian court. Article 26 deals with cooperation and direct communication between IRP and foreign courts or foreign representatives. Article 27 is the form of types of cooperation. One thing I want to make it very clear that if an Indian IP goes to a foreign court, to a foreign jurisdiction, and does not obey the rules of foreign jurisdiction, mind you, we have a limited jurisdiction which we had in Article 10. That doesn't mean that he will misbehave or raise his voice in the court, because if he does that, he would be liable to be punished by the court of that country and also by the regulator of the country from which that the appointment holder is from. That is important because there are a lot of case laws on this where foreign representatives have been reprimanded, have been fined because of their acts. Now we'll talk in detail about the cooperation, coordination, communication part, because now when we're talking about this, one of my main concern was that the speeds at which the foreign courts operate and the speeds at which the Indian courts operate, that has to be in consonance. It cannot happen that Indian courts are slow in providing adjudication, and foreign courts are very fast, so it has to work, they have to work in consonance. So this is very important for cooperation, coordination, and communication to happen between the courts. Now, on this also, cooperation, coordination, and communication, many organizations have been working upon that. The American Law Institute had their own guidelines. Then there were COCO guidelines, which are called the EU Cross-Border Insolvency Court-to-Court Communication Guidelines. And recently, in 2016, the Judicial Insolvency Network in Singapore drafted guidelines for communication and cooperation between courts in cross-border insolvency cases. And these guidelines have been incorporated by many jurisdictions. GIN has been now the latest one, and it has been incorporated by almost 16 to 17 countries as of now. Why is there a need for judicial cooperation? Like we saw that different legal systems, common law or the civil law legal systems. So the difference between these two legal systems have to be taken care of. The judges have to talk to each other, because when the assets of a company in different jurisdictions need to be taken care of, the judgments have to come in consonance with each other. It cannot be that a court in one country says something and the other country court says something else, and then there is a mixture of pluses and minus, negative and positive judgments, which would affect the treatment of that insolvency, the collective part of that insolvency, as well as the courts also, because they would be going in a different direction as far as judgments are concerned. So that is why the judicial cooperation is needed in these sort of situations. Then because of like some countries might be more towards territoriality, some countries would be more on universalism. So to have some sort of a balance between these two, the judges need to talk to each other and decide whatever rules and regulations need to be decided, because like I told you, there are no procedural law in terms of coordinating these insolvency matters in different jurisdictions. So the judges need to talk to each other to understand this. Now, conducting communication with different time zone is a very big issue. If we are when I was I'm an Insol fellow as well. So when I was taking my exam for the Insol fellow, we were supposed to address US court, actual US court, bankruptcy court in Southern District of New York. And my time of addressing the court was 1 o'clock at night. Right. So it is a nightmare actually. So different time zones and the language. See, US, UK, Australia, Canada works in English. But when you're talking about France, you're talking about Germany, you're talking about any other country which is not talking in English or corresponding or communicating in English, that becomes an issue, because then proper legal validated translations need to be sent to each of the judges to understand what is the actual situation, and that is very difficult. Inherent mindset of judges is very important. Like I said, they have to work in consonance and the speed has to be there. If one court works at 100 kilometers an hour and others works at around 40 kilometers an hour, the coordination would not work. The people will come and then go away because the decisions have not reached the proper places. So the mindset of judges has to change. The definition of courts in various jurisdictions is different. So some places there are administrative courts, somewhere there are, like we have NCLT courts, some there are specific bankruptcy courts. So the situation should be that these should work together. Whatever be the designation of a judge, doesn't matter. It has to be the coordination between judges who are adjudicating on a specific issue. Actually, this whole the judicial cooperation and communication, I had written a paper on this, and that's why I'm just referring to my paper. So resolution of substantive issues on public policy, burden of proof, avoidance rules, protection of domestic creditors, or other rights granted to a party by the Constitution or conflict of laws are to be observed and taken care of. Lack of rules and legislative framework. This is regarding judicial cooperation between courts in many jurisdictions. There are no rules, so rules have to be framed. We'll be coming to how the rules are framed. Rules of procedures again will need to be framed so that people have right to be heard, neutrality of the judge, taking evidence, etc. Mode of communication. Mode of communication. A judge in England cannot come down to India to have a hearing here. So it has to be through video conference or through. There are instances between Canada and America where 30 years back or 25, 30 years back, they were interacting and cooperating on telephone because there was no video conference facilities available. So they were interacting on telephones. The mode of communication is there. So how do we have these rules in place? So for the rules, we have what you call the protocols. I don't want to get into the details of protocols because I will show you an actual protocol of Jet Airways, right? So the protocols are basically soft laws which are not binding and provide for means and ways to promote communication between various stakeholders. They do not provide the ways to set up and conduct a mechanism of initiating communication between the courts and other stakeholders. But for coordination of global, let's skip this part and get to the.
So just to have a grip, you've taken the part 1 and you're of the UNCITRAL and you have moved to the part 2, or
No. The UNCITRAL model had those 4 provisions of access, relief, recognition, and coordination.
okay.
Right now, coordination, how the coordination takes place is through protocols.
Okay.
Right now, Jet Airways case also had a protocol. The Dutch insolvency representative and the Indian insolvency representative entered into a protocol. How to manage the whole case between the 2 courts. I'll be showing you that protocol.
I just wanted to understand from the flow of your presentation. Just to reiterate, the part 1, part 2, all these are available in the UNCITRAL. So we have covered almost part 1. You have covered almost all the articles you explained.
Yeah.
So now you are going for the procedural part of it. Am I right in?
Yeah. How do we do it? This is basically a private agreement between 2 people. Two representatives, insolvency representative from different jurisdiction. Okay. And these protocols are probably, I would not say should, but in India they have to be stamped by the court. I mean, they have to be cleared by the court, right? I don't know about the other jurisdictions, but yes, for India they have to be cleared by the judges, which they did. So let's take the Jet Airways case first. Jet Airways is one of the biggest organizational failures to happen in India. 17th April 2019. Jet Airways case shut down. Prior to that, the plane operating flight N9W321, which was a Boeing 777 to Amsterdam, was seized by another airline over non-payment of fees. It is also believed that lessors are planning on seizing all the Boeing 777 aircraft used by Jet Airways if and when they land at the Schiphol Airport, Amsterdam.
Sir, just for this, I was part of GE Capital at that time when this funding was done. And this entire 95% of the fleet were funded by the GE Capital through one of their outfits. So when you say the lessors, it means that they are the people who took the action? Or is it that, some of the operational creditors who have taken
It is operational creditors. not the
operational
lessor.
credit,
Yeah,
not the lessor?
not the list. No. At that point in time, one aircraft landed in Amsterdam, right? And at
Yeah.
that point in time, there was some operational creditor, probably it's a fuel agency or the airport agency, which were not given the demurrage charges or whatever. They wanted to seize that aircraft. And at that point in time, the Jet Airways was going through a very bad phase, right? And the payments to the lessors were not being made. And the lessors was also thinking of seizing all the aircraft. And the operational creditor in Amsterdam at the Schiphol airport was thinking about seizing any other aircraft which lands in Amsterdam. He would have a lien on that.
Lien on it, okay.
Okay. Seventeenth April, it decided to shut down its operation. Now, Naresh Goyal had taken a lot of funds from lot of people, and there was trouble brewing since August 2018, and DGCA conducted a financial audit of Jet Airways at that point in time, and at that point in time, Jet Airways posted a net loss of 1323 crores, 1,323 crores. Thereafter, in September 2018, I'm just giving a background why this thing happened. In September 2018, the IT department surveyed the Delhi and Mumbai offices of Jet Airways. There were financial irregularities, financial misappropriation. I would not say Naresh Goyal was involved, but Naresh Goyal was then the founder chairman of Jet Airways and was under the radar of government and the law enforcement agencies. And Naresh Goyal and his wife both stepped down from the operations of Jet Airways on March 25th, 2019. Now you see the dates, 25th of March, they stepped down as the directors of Jet Airways. And then they were trying to flee from India in May when they were stopped in Mumbai and they were deboarded from the aircraft. They
You
were
were not
charged.
lucky like other friends. He did
Yes.
people in the government.
Yeah. So there were charges of money laundering and foreign exchange violations against both these people, and they were questioned there. So Jet Airways shut down its operation on 17th of April 2019. At the point of shutdown, there were 20,000 employees who were directly affected. Millions of dollars was supposed to be paid to National Aviators Guild, and they were asked by the employees asked the PM and who was the Minister Suresh Prabhu, the Civil Aviation Minister, Mr. Suresh Prabhu, at that point in time, to do something about it. 21st of May, Jet Air was declared bankrupt, and the Dutch trustee was appointed to manage the estate of the company. Now, this declaration was done in Netherlands, in Amsterdam, on 21st of May. Rocco Mulder was appointed as a trustee in the Jet Airways case, appointed by the Noord Holland District Court, Trade Subdistrict and Insolvency in the Netherlands. 18th June, State Bank of India filed Section 7 application at the Mumbai bench, and Mr. Chacharia of Grant Thornton was appointed as the insolvency resolution professional. Now, what happened after this? The whole process went, the whole CIRP process happened, and Jet Airways bid was done by Calroc Jalan Consortium, which had proposed a total cash infusion of 1,375 crores, which included 475 crores to the stakeholders' payment and to other financial creditors. Now, what has happened? Today is what date? 9th. 6th of December. 3 दिन पहले, 3 days earlier. Jet Airways Cabin Crew Association filed a liquidation application before the Mumbai bench of NCLT on Tuesday, the Tuesday which has just passed away, seeking liquidation of Jet Airways assets on the ground that there has been a contravention of the resolution plan. Any further delay in liquidation process, the associate said, will reduce the value of assets of the debt-laden in the airline. This is the Mint news of 6th of December 2022. So the situation is bad for Jet Airways as of now.
Where is 180 days? And where is 3 years, sir? 180 days, we are talking about the entire process. And we are talking
So the
3
point
years.
is that let it be 180 days or 3 years. The point is that the company couldn't be saved. I think it would go towards liquidation because the provident fund dues and other dues which was supposed to be paid were not paid because of the precedents which have come out later.
Recently.
Yeah. So that is the basic issues that are being involved in this liquidation application which has been filed.
When we were taught the insolvency, we are taught basically that the waterfall mechanism were created with the understanding that the operational creditors, the governments, all of them had all the opportunities until the company had become bankrupt to recover their dues. Now, once again, we are saying that no, we need to recover for all of them, and we leave the public sector, banks and other people, particularly financial institutions, to go and beg. So now funding is going to be very tough from the banks, from the perspective, if this is the way that this insolvency is going to take the shape in India.
So it has gone from bad to worse. That's what I feel. But the point is that at certain point in time, corrections will come up automatically. The courts which had been given judgments earlier have reversed their judgments in some matters, which has helped the insolvency regime in India. The only thing that I can see is that the threshold limit needs to be decreased to make it much more operational and more people to take. See, getting companies into liquidation or insolvency is not a big deal all over the world. I'll just
Except India, sir.
no.
India.
Yes. Okay, I'll take that slide first, probably. Just wait. It's I just wanted to tell you about this. I'll take this slide. Yeah, this. What we did for last 2 years, that I was leading a project for Insol International, where we had people around 60 team of 60 lawyers and accountants from 29 jurisdictions worldwide, and the impact and consequences of COVID-19 relief measures were taken care of. I mean, how it is happening in different jurisdictions, insolvency, how the insolvency regimes in various jurisdictions work, policy measures which could be adopted to enhance the efficiency and effectiveness of the insolvency outcome for MSMEs and the stakeholders, and the use of mediation in insolvency in various jurisdictions for faster and timely resolution of disputes, the stigmas associated with insolvency, how people can come out of insolvency. All these things were taken care of in 29 jurisdictions, and this project went on for 2 years, since 2020, and the report has just come out in the first week of December. I can also show you the report, a bit of it, and this is available at the insol.org website. So this is the whole project was all about MSMEs, practical challenges and risk mitigation post COVID-19. Here you will find that whatever you were saying about the threshold limits going back in most of the jurisdictions except India, probably another And these are from Argentina, Australia, Austria, Brazil, Bulgaria, Canada, Chile, Croatia, France, Germany, Hungary, India, Japan, Malaysia, Mexico, Myanmar, New Zealand, Nigeria, Portugal, Romania. Romania is being done by one of the judges, Dr. Nicoleta. Singapore, South Africa, Netherlands, Turks and Caicos Island, Uganda, UAE, United Kingdom, USA, and Venezuela. So this report is almost more than 350 pages, and which is available at the website of Insol International. And luckily, I was the lead in this this project. So all these people were there to provide us the input from different jurisdictions. So effectively, if we talk about various jurisdiction, our threshold limit is so high that people have not been able to actually use that threshold limit for their own benefit. So this has to come down. It is not only for saving companies from insolvency, it is also people might say that it is not for recovery, but why are the banks and big creditors using this for? They're using it for recovery, only for recovery of their assets. How much of those cases are being restructured? That is the point. How many companies are being kept as a going concern? That is the issue. Most of them are being liquidated to recover money. And that should not be the case, because that is directly going to affect the GDP. That is going to be directly going to affect a lot of things. So coming back to the Jet Airways protocol. So this was between Ashish Chocharia and Rocco Mulder, Dutch trustee. So how do they do it is that they give the recitals first. Why is this being happening? So in the recitals, they would say that because this Dutch trustee was appointed because of such and such order of the Dutch court, and to facilitate the cooperation between both the individuals, the Chocharia and Mulder, this protocol is being put up. The purpose is that to coordinate and cooperate, coordinate and communication between both the resolution professionals from Holland as well as India, it needs to be taken care of. The protocol represents a statement of intention and guideline designed to minimize the costs and maximize the value of assets recoveries for all creditors of the proceeding by promoting the sharing of relevant information between the parties. Now, this application was filed because the COC of Jet Airways did not allow Mulder to be part of COC meetings. Right? So that's why it was the whole of the protocol was copied onto this order.
Just because he's the operational creditor, sir?
No, because he's the Dutch insolvency representative. They said we do not want him in our COC.
What is the object, sir? If these permitted...
They don't want a third party to come into the COC. So this protocol said that he could come into the COC. So they changed that specific clause that he cannot come into the COC. Okay. Now, the court ordered that you are wrong. COC doesn't have to do anything between the agreement between the Indian representative and the Dutch representative. So he can appear, but will have no right of vote. That makes sense. So this is the order which says that, but this is also the order which actually has duplicated or copied the whole of the protocol into the judgment. So in recognition of the substantive differences among the proceeding in both jurisdictions, this protocol shall not impose on the RP or the Dutch trustee any duties or obligation. That may be inconsistent. That means that if there is any inconsistency between the substantive law, that would be taken care of by the courts, not by these people. And the aims of this protocol: coordination, communication, information and data sharing, preservation, claims reconciliation. Very important, because there could be claims which can be made by single creditor in both the jurisdictions. So that is important. Maximization of value of assets, committee to maintain the independent jurisdiction, sovereignty, authority of NCLT and the Dutch bankruptcy courts. So how the information would be taken up, given out, these are part of this protocol. You can go on the Google, type Jet Airways protocol, and you will find this. Right to appear and attend, this was the main thing that which was taken care of by the court. The Dutch trustee in the Indian proceeding. In spirit of cooperation, the Dutch trustee aims to not take any decision under the Dutch proceeding that would adversely impact the interest of company or the creditor. That means that before he takes any such sort of action which is adversely affecting the creditor, he would tell the Indian court about it. And then they will decide what needs to be done. So this is a very long protocol. I'll just go through it. What to do with the assets? They would not sell the asset. The spare part, the office inventory, the value of flight slots at Schiphol Airport. The moratorium is also included in this. Claims, how they would be filed, how they would be collated between the Dutch trustee and the Indian trustee. The Dutch trustee and the Indian representative. So if the Dutch trustee has received some claims, he would inform them. If the Indian representative has received some claims, he will inform them. Then they will start collating it. Some claims might have come to the Dutch trustee prior to the initiation of insolvency in India. So how they are to be treated, that are also how they are going to do this in this specific protocol. Costs. See, every time IP takes care of his costs, be it a protocol or anywhere. So they have also said that whatever costs that have been incurred or would be incurred would be payable by the creditors. That's not an issue. The stay of the proceedings, the validity, and so these are all the boilerplates coming up. The committee is important, that both the parties, both the courts would have committee with each other. Now this says that trustee shall be invited to participate in the meeting of CAC as an observer, but shall not have voting rights. But the court has changed the language to this, because the resolution instead had said that the trustee shall not be entitled to participate in the meeting of COC. So this has been changed to this. So the final is this one, that the trustee shall be invited, but have no right to vote. But we make it clear that the trustee will work in cooperation with resolution professionals of India. If any suggestion is required to be given, he may be given to the resolution professional. Draft of the CBI protocol is made final as above. So that's the protocol that I was speaking about. Now we come. You have heard about the FTX case? Anyone?
Which case, sir?
FTX case?
No, sir.
FTX was a crypto exchange. Right? So just give me a moment. Let me just take out some other thing as well on FTX. What they would use in the FTX crypto exchange was, it was just like a stock exchange where they would sell and buy cryptocurrencies. Now, cryptos are not regulated anywhere, and the amount of transactions and the amount of investment was of billions of dollars, billions and billions of dollars. But FTX collapsed overnight. What FTX did was, that they had another sister company called Alameda Research, and FTX money.
Heard about this, sir, that the group company transferred between FTX and Almeda. Now the second name gave it, and he admitted that yes, the money in fact had been
Yeah.
so tens of billion which you are talking about, or
Yes, billions of dollars were
yeah, I am aware, sir. I'm aware.
were siphoned out to Alameda Research for risky
Correct.
investments.
Correct.
Right now,
So this is not even in India, sir. It's
It's
global
not a-
phenomenon.
no, but this has very implication in the cross-border insolvency,
Agreed.
where the economy is shifting, and this is something which is to come in the near future. It's just talking about it just started. It started in, I think, November. The bankruptcy started in November, I think.
But anyway, in India, cryptocurrency is illegal now, sir.
No, it is illegal, but people who are having accounts with the FTX, they are trading there, so they are going to be affected somehow or the
But
other.
that will be coming under FEMA regulation.
That is post.
Unless your money is earned and accrued outside the India.
Yes, so that is
FEMA
something
violation
which
no,
we're
sir.
talking about the criminal matters. No, we're talking about the rights
The
of
financial
people.
impact.
Yeah, international impact in terms of how it is
Sure.
going to be affected, because
Sure. But the legality will also come into the picture the moment.
yes. All those
whatever,
see,
sir.
that is besides the point. Yes, whatever legalities or illegalities are there with respect to cryptos in India would effectively come out in case there are some investors, and there are billions of investors in this.
Right.
So
So it is so lucid, sir. In this case, it's the best example of the crypto. Why people should avoid. It's in the private hands, and one individual can swallow all the money and run away.
yeah. So Alameda Research took care of almost $8 billion. It went into a hole. Nobody knows where it went. Right. And a Chapter 11 bankruptcy was filed to reorganize the business debt while allowing it to operate. But the collapse of FTX was so fast and so soon, within a month or 15 days time, it collapsed because everybody started asking for their money, which they couldn't pay back. So on an emergency basis, they filed Chapter 11 at the Delaware bankruptcy court. And it is going into a liquidation situation. Almost 130 entities which were under FTX are now a part of that Chapter 11 proceeding. 130. John J. Ray III was appointed as the insolvency representative, who was also the insolvency representative for Enron. There is another Bahamian company. Chapter 11 filing has been done. And simultaneously, Chapter 15 filing has also been done. How is it possible that the main proceeding is Chapter 11 filing and non-main proceedings to recognize is Chapter 15? Both have been filed. Now, this has created a situation where cross-border insolvency rules and regulations have gone for a toss. A company is filing Chapter 11 to be recognized as a foreign main proceedings, and simultaneously filing Chapter 15 to be recognized as non-main proceedings. So, I'll show you the organizational chart. So this is Sam Brankman-Fried, Gary Wang, and Nishad Singh. So we also have someone from the Indian origin in this whole scenario. Now this is the organizational chart of the FTX.
Thought is not visible, sir. Only you're getting the heading.
I'm shifting it. Can't you see that?
No, we are able to see only the organizational chart as a thing, but not underneath anything.
Okay, I don't know, but this is a copy of the organizational chart that I have.
Just move
Anyway.
down, sir. Maybe you need to move down to the next page.
Is it visible now?
I don't see.
Anyway, so this in this there is one company called FTX Digital Markets, right? So the main company is situated in Bahamian Palace. This is called Bahamas. Okay, this is Bahamas, and the Bahamas company is FTX Digital Markets, which is not a non-debtor company, which is a subsidiary of some other company. And this chart which I have, which is not visible to you probably, this is such a mix of holding and subsidiaries that it has been said that this has been specifically intentionally done to take care of all the wrongs that have been done so that it cannot come out because of the intricate nature of these holding and subsidiary companies. So what has happened is that the main company filed a Chapter 11 filing. When the Chapter 11 filing was done, that meant that the company is asking for restructuring and the foreign main proceedings would happen in US. Now, the Bahamas company, which is probably a subsidiary, I'm not very sure because do not have the primary information on that. They filed before the Chapter 11 filing was done by the Delaware company in Delaware. They filed a Bahamas before the Bahamas International the Insolvency Court. They filed a insolvency petition in Bahamas a day prior to a Chapter 11 filing was being done. After Chapter 11 filing was done by the Delaware company, they asked for a Chapter 15 filing in Delaware regarding recognition of the Bahamas insolvency proceedings as recognition of foreign main proceedings and the US proceedings be termed as foreign non-main proceedings. Now, in these two filings, they are totally, there's a dichotomy between these two filings. You cannot have these two filings together by the same group of companies. Now, a big fight is in store in the US with huge amount of revenues to be earned by the lawyers and accountants on this specific thing. And mind you, this can go on for many number of years.
And like Enron, it will vanish and nobody will know.
The
And
main
who
point
enjoyed
of
the
this,
money.
the main point in question here is that what is going to be the quantum which would be recoverable by the creditors. Now, who are the creditors in the first instance? Are they the investors or are they simply depositors or are they the creditors? The investment made by the crypto investors, like if I had made 100 rupees of crypto there, would it be treated as an unsecured claim without collateral rights or with collateral rights? How would I recover those? Because everything is in the air. There is no regulatory body to regulate cryptos.
Maybe to prove the case only, this case has.
Okay. Now, second thing, some investors withdrew 6 to 7 billion of cryptocurrencies before FTX went down. Okay. Now, the question again would come up whether this was withdrawn by the investors as their own money or there would be a clawback of the withdrawals. Right.
if the case has got more of the US and Europe citizens losing the money, this will find
Yes.
very fast. If it is for the third world, according to US, if it is third world, it may never be a record by the people.
Now, ultimately, which court is going to be, which jurisdiction will have the COMI, that is also to be decided. Bahamas court has decided the COMI is in Bahamas, and US court has decided that it is the US. COMI is in US. Again, there is an issue. Until this issue is decided, the case will not go on. Because the whole total system would change if both the jurisdictions are claiming to have the foreign main proceedings.
Sir, you know very well Bahamas would be a conduit only, so it may not take much longer.
Not necessarily. We in India think that Bahamas, Caymans, BVIs, Cyprus, all the tax havens are conduits for money. But let me tell you that most of the businesses, the legitimate businesses, the legal businesses in US, in UK, use these tax havens just to
I do agree. As an investment manager, have used all these islands, and we have, like, even major funds been routed through there. But that's not the case. But the de facto control, if you ask me, is 100% not remaining in Bahamas.
No, agreed on that, but you have
De
to
facto
also take into account the actual legislation, the statutes which are available in Bahamas or in US. How the that is why the cooperation is needed for the courts to decide between themselves. This is the.
So that's what I'm saying. In this case, since yours is involved, since they have to earn the money, I can.
And moreover, Delaware.
In Iraq, they were ready to kick out even UK, and they did not give even given a single oil rights directly to any UK company, since they did not participate. So since yours is small, you can be rest assured that it will be yours winning the way.
No, see that if Bahamas court put its foot down, then and then it is going to be a khichdi. You cannot get out of this khichdi. But the point is that Delaware and the New York, Southern District of New York, these are the two bankruptcy courts which have the most bankruptcy filings in US, and combined they have almost 60% filings of total US into these specific two courts.
Because they are expert, they
are experts, but since the federal nature and the state nature of the various states in US is concerned, the bankruptcy court rules and regulations are much more harmonious for the stronger there in Delaware and in the Southern District of New York.
Agreed.
So this bankruptcy is going to set new precedents in the US on how the rules and regulations are going to come up. Right? The crypto world is going to be shaken out in this. And importantly, the cross-border issues that would come out would be very important to see how the Bahamas court and the US court act in future. That is for us to see in future. I cannot comment, determine anything on today's date. It would happen in future, and we'll wait and see what happens. And the insolvency representative John Ray said, "Never in my career have I seen a complete failure of corporate controls and such a complete absence of trustworthy financial information that has occurred here. This situation unprecedented." So there are no regulator. They just collected all the money.
It is John Ray who's sitting in US. As RP, he can talk like this. In India, we cannot even voice like this. And thankfully, he has handled Enron. So obviously, he has got enough financial muscle.
So the point is that this is a fit case for understanding a cross-border insolvency in future, and there would a lot of changes might come up in different jurisdictions, because cryptos hawa mein hota hai, it's all in the air, nothing tangible actually. So now coming back to the draft framework for cross-border insolvency in India, the key points are: it is relevant for the resolution of distressed companies with assets and liabilities across multiple jurisdictions. Broadly, the cross-border insolvency pertains to those debtors having assets and creditors overseas. A framework for cross-border insolvency proceedings allows for location of such a company for company's foreign assets, the identification of creditors and their claims, and establishing payment towards claim, as well as process for coordination between courts in different countries. So coordination is also a specific part of the Part Z. The need for having robust institutional arrangement to deal with cross-border insolvency issues has gained momentum in various jurisdictions, particularly under the aegis of installed model law during the last few decades. And this can be seen in various conferences that we have been attending across the globe, where people have been putting together their ideas. And for last 1 year, Singapore has been in a big way coming up as a major cross-border destination. Now, the potential impediments to the cross-border legislation in India. Like I said, requirement of speed in decision making is very important. Timely intervention. Time is of essence in any sort of an insolvency. Sensitization of members of adjudicating authority. I believe they are basically have a commercial mindset, not the insolvency mindset. I've seen US courts and the British courts working, and they don't wait for
even the German and Swiss courts, the way they work and the way people operate is entirely different.
Again, German is a civil law jurisdiction. They would work as per the law only. They would not go daएं or बाएं. But the common law jurisdictions, courts, have the natural justice to take care of as well. So, but what I have seen is that the speed at which they work, that if an issue has to be decided today because something is going to happen tomorrow, they will decide it today without waiting or wasting any time. Executing the basic principles of insolvency and the implementation in the directions by the adjudicating authority. Collective proceedings. Now, these are the things. Collective proceeding is that creditors have to get to the court in a collective manner using different, say there are 5 jurisdictions where the IPs are there. So all have to work in a collective way with the courts. Right of access, relief, and recognition must importantly be the coordination and the cooperation. Collective proceedings, right of access, relief, recognition, and cooperation coordination should be there, which should be handled by the courts in a proper way. Because if not, then the whole cross-border insolvency scenario would just burst in their face. Application of principle of public policy and its process. Like I said, manifestly contrary to public policy has to be seen in its narrow sense, not in a wider sense. Adjudicating authority to have more powers of self-determination in cross-border. So the adjudicating authority have always had the power of self-determination, except that they do not choose to put that authority in a working area.
Actually, we should distinguish between our judicial and other people also, like Nariman kind of exceptional judges should handle special cases, at least so that our rights of the country.
There is some talk about putting up special insolvency courts in India and NCLTs. So this is a talk. I don't know how much time it will take for execution. Anyway, importantly, what's in it for us? Right of direct access to the foreign courts. Can intervene in foreign insolvency process. Now tell me one thing. As a lawyer, right, I cannot appear in a foreign court. Okay. As an accountant, can you practice your profession in some other country?
Yes, sir, we can practice.
No, can you put a stamp and
yes, sir, we can do it. For example,
lawyers
we can do that, sir, provided like the country recognizes and we have got the understanding between the countries. For example, the best example is the Middle East, where I was even part of the government of Oman. Almost like the sitting benches of Indian back office of Indian RBI or anybody.
Lawyers can't do that.
people who are like this central bank or anything.
So lawyers can't do that.
Lawyers
But
cannot do that.
but
I
the
mean,
part-
even chartered accountants cannot do that unless there is a treaty, there is an agreement. We have largely we have crossed those stages in many countries.
so no, lawyers cannot do it anywhere, right? This is a very long debate which has been going on for last 50 years since the Advocate Act came up. But Part Z of the Indian cross-border insolvency has taken this into account, saying that lawyers cannot go out, but yes, insolvency professionals, which is a profession in itself, they can go and appear before the foreign courts. But this still is a proposal. I don't know whether it would come out as a final act. I don't know, but this is what the Part Z has.
Sir, one thing we have learned, sir, even in Indian, even if we are allowed in NCLT and CLAT, we can appear. We always take an advocate and go along. So I would appreciate that, you being professional, you should take a fellow professional from that country, which helps. Primarily, most of the countries where we are going, the language itself is going to be a barrier, except where it is a English ruled place. So it's better to have the local person and let more people learn rather than.
So IPs may be appointed as authority for foreign representatives in India, inbound. I mean, and the outbound can also happen. There is a duty to act judiciously. Any misconduct or maleficence may have consequences for the IPs in foreign jurisdiction and also be subject to scrutiny by IBBI. Duty to be bound by principles enshrined in the upcoming legislation, the cross-border part of Indian part. In case of cross-border scenario, expert knowledge is required, which may result in better monetary benefits. Yes, I've been waiting for it, but I have not got anything. Right? But yes,
Sir, we'll discuss off ground regarding at the Singapore.
No, we have been getting some opinions on cross border because in Chennai, you are in Chennai, I think. So
Yes, sir.
Chennai, we have got a lot of companies in Chennai, Tamil Nadu, Andhra, Karnataka, where they have group companies in Myanmar, Vietnam, Indonesia, Singapore.
Particularly Korean companies,
Yeah.
everything we have.
These people have approached us for advices on cross.
We are representing and we have got legal counsels also with whom we are coordinating from the respective countries.
So these are coming in, but as you know, the recession is set in across the world. There's going to be we're getting news from our lot of friends across the world who are lawyers that the insolvency filings are increasing across the globe. India has, when it opened up in 1990 to international businesses, is going to be affected in some way or the other, somehow or the other, in some capacity or the other. But because of some sort of protective environment that we have, we may not be affected largely to the extent by insolvencies of large corporations. But yes, India is going to be affected in a small way. So there is a lot of opportunity.
Till now we are gaining, sir. I don't think that we should really worry about it. And
no, you can't say because
I hope we'll be gaining in the future.
You can't say that because earlier we used to live in a vacuum. Now we're not living in a vacuum. Somehow or the other people are going to be affected because MSME, I'm more concerned about MSMEs, not about large corporations. And MSMEs, if they survive this part of recession, then India can move ahead very fast. But the question is still
So
a question for us.
even Indian legislations are not supporting the MSME. It's only the namesake it is supported.
Yes. Yeah.
So it has to be taken on a separate session if we have to discuss on the support by, even the legislation and the government intention to support the MSME. It's only by the words, sir. Even the banks, financial institutions are not supporting any MSME. It's only in the namesake, sir. So
Yeah.
about MSME, they're not going to be long.
So that's what we are trying to change.
How we are going to change? It's going to be a very big $1 billion question.
So 63 crores MSMEs in India. Sorry, 6.3 crores MSMEs in India.
Sir, all those are fine, sir. How many are just the frills and the supportive companies for the main companies, if you think, and how many go bankrupt every year on year? I can give you the study separately, sir, because I'm on the other side of the board where I'm supporting every company who's dying to survive. So I support them like an outsourced CFO, and they are bleeding, sir. Every large corporates are eating away them and then throwing them into the dirt. And eventually, of course, there is no end, sir.
That is the issue. That is the issue that we are trying to tackle.
It is difficult, sir. It is difficult. They are using them as a conduit and just throw them. They are just outsourced and they remain as an outsource, and they are sucked, and their payment, even 1 or 2 months, they hold it and they die. So you can go on cribbing that, the MSME to be taken care of. Where the legislations are available to you, important cases, sir. Who will handle for all this?
We are actually trying our best to bring mediation as a part of insolvency framework, right? The simple reason being that the courts are inundated with the courts which are there in India. The insolvency courts are inundated with lot of litigation, and they cannot handle the litigation because of the number being very small, right? And if somehow or the other we can decrease this the quantum of litigation to 50% by using mediation in insolvency situations or a pre-insolvency situation, then probably we might have a situation where the courts would be not burdened with so much of work, and they could adjudicate on different issues in a faster way.
Sir, they don't know how to come to you, sir. You need to go to them.
So there's a lot of people.
They don't have a CFO. MSMEs, if you talk about, they don't have CFO. They have got accountants. They've got chartered accountants and many of the other professionals acting as accountants, but they're accountants. They're not treasury. They have zero knowledge. Some people with as regards to treasury in India is concerned.
So that is what we are trying to achieve. There are some of my associates have started this process of connecting with MSMEs, but the point is that as an individual, it would be almost difficult for me or for anyone else for that matter to connect with all of them. We need the support of the state governments, the Chamber of Commerce's, the lot of NGOs who should be involved in this whole process, so that people can come to know the areas where they can actually get help from.
Sir, the main problem is we were given a lot of example, like the ex-president Donald Trump being 4-time declared bankrupt, and he still went on to become the president, and he runs a lot of businesses.
Do you know that at one point in time, Apple went bankrupt?
Yeah.
And it was the Microsoft which brought them out of that mess. Bill Gates was the person who gave them the money.
Understood. But what is the point in Indian context, sir? If you become an insolvent, even if you have slipped for even as an NPA, you will not get the next loan because they want a clean slate. You go to any banks today, they want a clean slate. How would you do that, sir?
That is, again, like coming back to my earlier point, the change of mindsets of the bankers as well. Very important. They are looking at their own post-retirement benefits.
Absolutely.
Right.
No, they take care of themselves, sir, very well.
Yeah.
The pre-retirement itself, they are planning with collusion with the promoters. There is no doubt about it. Otherwise, there's so many insolvency cases would not come at all. The kind of fielding that they do for every case, I don't want to mention, but the major bank in India and their the approach towards that, the whole of the insolvency, if that alone changes, I'm telling you that this insolvency will be a very big success. I don't want to mention the bank.
Let's hope in the future it helps. Now, just coming back to the cross-border, one of the case I want to discuss is the Lehman Brothers case. I had actually, before the jet air case, I was supposed to do that. But since now we have some time, so I can do that. The Lehman Brothers was a
So
was a-
this 2008, 2011.
yes, 2008.
Okay, fine, sir. We are aware.
So Lehman Holding Company was incorporated in US with subsidiaries in various countries. Now, Lehman Brothers went down in 2008. At that point in time, there were almost 16 countries or 16 jurisdictions where they had their operations in, and 75 subsidiaries. And millions, thousands and millions of people who were there, traders, their depositors, their investors and all. And when it went down, it was a mess. People thought that US government is going to bail Lehman Brothers out because that was the biggest merchant bank at that time. However, when it went down, nobody helped it. From September 15, 2008, more than 75 insolvency proceedings commenced over time in respect of Lehman Brothers in some 16 jurisdictions worldwide. Until date, last month I was also reading one of the judgments which had come out from US with respect to Lehman Brothers in one of the matters. These proceedings involve different type of insolvency proceedings and different administering bodies like judicial, administrative, governmental and regulatory in different jurisdictions. Prior to commencement of these proceedings, Lehman was the biggest financial services firm in the world. Now the point is that how did they undertake such massive insolvency on a global scale? How did they do it?
Almost all the governments got involved, sir. India, RBI.
Again, coming back to my earlier comment, most of these cases with the depositors and the creditors were handled through mediation. Lehman Brothers was the first case where mediation was used to actually sort out cross-border insolvency, to sort out issues, sort out different disputes, so that the courts had very minimum disputes to adjudicate. And in terms of what it has been, almost 15, 16 years since Lehman Brothers went down, still the cases are going on. But
Sir, thankfully, it had the property underneath, though it is 5% value when it run down, because it's a 20 cycles of, they have done it. And I hope you know the case, and the step down, which has become, it has come back to the same, like Lehman Brothers, where they have lent initially. If State Bank lent, and it has come back to State Bank after 20 cycles back into their own. So that is where the problem started.
And mediation
happened
helped
in India.
Mediation helped reduce legal costs by over $4 billion. And that is a fact I'm talking. Right. So we have to see how mediation can help us in a big way in India. And we have already started doing that in some way or the other. And in near future, you will see a lot of, and mediation has become a hot topic internationally in terms of cross-border insolvency and international insolvency in various jurisdictions. I was attending one colloquium of jurists, lawyers and accountants in London in June at the Insol conference. Insol conference finished on 28th and 27th, and this was on 28th. And there were almost 100 people there in that colloquium who were stressing that mediation should become an integral part of the insolvency proceedings across the globe to bring down the number of adjudicating issues which are left to the courts. And it makes sense to us. seeing the Lehman Brothers case. Makes sense. Otherwise, I can rest assured that if mediation was not used, Lehman Brothers would have gone for another next 10 years. So I think now we have time for, I've already showed you this, question and answers. So anybody having any questions?
The first question, what did you qualify? You said I missed out a very important point. You are basically a advocate.
I'm a lawyer. I'm a lawyer.
And how did you go on to get the qualification install across global?
Well, long story, 2014, 13, 14, one of my clients asked me for help in his restructuring. I was doing some work on insolvency, not much. So I started off with restructuring 2017, that 16, 17, the act came into place, the IBC code. 2018, I became an IP, right? But then again, it was not, I was not very keen on being an IP. Then somehow I got something, some I think mail from Insol International or Insol India. So I just applied, and it was quite an expensive proposition at that point in time. But I said, okay, if we have to go to insolvency, let's go the whole way. Why stop at Indian insolvency professional? So I did that.
Do you need to be an advocate or a legal?
No, not necessary, not necessary. But yes, this is a profession for lawyers. Out of 25 people, only 6 were accountants.
Okay.
In my batch.
6 were accountants.
So we had to go across the world. I was in London in 19, and I was supposed to be in Cape Town in 20, and then again in New York in 20. Then COVID hit. So we were delayed by 2 years. So last year I got my certification from Insol International as Insol Fellow. I was the second fellow in India. After
So
me,
what would it require to qualify? Sir?
Nothing. You just have to be at least minimum 5 years of experience of insolvency. That's all.
Okay.
Yeah, that's it.
Okay. Luckily you have. So we are. I started in 19, so we are ready to go further. 2 more years.
It is fine. I mean, we are having an Insol conference in February, I think.
Okay.
The 3rd of February. So if all of you would like to attend, please do attend. That would be very, very, very knowledgeable.
We need to register under Insol. What is the website you said, sir?
You can go to Insol India website and
Insol India website and go to the
Insol India website and see if you want my help. You can give me a call or give me a ring.
Please share the contact details. Okay, I'll just take a snap. Though I had requested the admin to share your presentation, request you to share your presentation.
I'll do that to Trishna. She'll then forward it to you.
Yes, sir.
Please.
Yes, sir. Definitely. I'll forward the presentation.
It's a very interesting session, sir.
It was mostly academic for all of you because it has not the cross border has not been legislated. But I've been into a lot of webinars where I have attended as a participant, and people are talking about cross border. I don't think you would have gone through all these things in the cross border.
Sir, I downloaded when you are present in an alternate computer. I downloaded all your Incitral, and I was just going through. And whenever you're talking about any articles, I was referring. I had never gone through without your help. So it's a really.
So you what you do is go on to Incitral website, right?
Yes, sir.
And there would be legislative guide. There would be Incitral model law.
We are able to download also the entire list.
Yeah. You can do that.
And even case laws, everything.
Mind you, I've gone through each one of them.
Okay.
I've gone through each one of them, and because get into that as an insol fellow, you need to have full knowledge about all these, and this one which I showed you, if you can download it, this would be a very big and good resource for understanding the insolvency regimes in at least these 29 jurisdictions.
Actually, we must thank for your time, and the CS Institute really has done a great job in bringing you somehow into
Thank you.
Educating us, sir.
Thank you, my pleasure. So Trashla, can we call it a day today?
Sure, sir. Sure, sir. Thank you so much, sir. On the behalf of ICSI, IIP, and all the dear participants, I would like to thank you for such an enlightening
My
session.
pleasure. My pleasure.
Thank you so much, sir. And thanks to all the participants for being a wonderful company and cooperating with the session. Thank you so much, sir.
Okay, thank you.
So
Thank
many
you.
has
Thank you,
bothered him. So other people want to take the time.
चलो भी चलो सुनिया है नहीं